Ladies and gentlemen, please take your seat. Your Excellencies, ladies and gentlemen, dear friends, it is a pleasure and an honor for me to welcome you on behalf of the EFTA Court to our annual conference. We have now been holding these conferences almost uninterruptedly since 2011. Although we do not have the same record turnout as for our 30th anniversary conference last year, where over 300 participants registered to celebrate, we nevertheless are sold out for this year's event, and a group of people is following on stream from our courtroom downstairs. Among the esteemed participants at our conference are judges from the Court of Justice and the General Court, the European Court of Human Rights, and Supreme Courts of EU states. We have, as always, an outstanding program with a number of distinguished speakers to taking part. Our keynote speaker is someone who needs no introduction to us working in the European law, Professor Takis Tridimas. He will be speaking to us about the many phases of the internal market and even looking beyond Europe. Well, personally, I must admit that I am not sure where in these days and age we can look for inspiration beyond Europe. However, I'm sure that Takis will provide us with an answer to this intriguing question. The next speaker on the agenda is Professor Nia Nick Bittner. She is leading expert on the free movement of persons and the author of an outstanding book in EU citizenship. As you all know, the EFTA Court has been handing down a number of interesting judgments on the free movement of persons under the Citizenship Directive. I, for one, await with interest what Niam will be saying with the latest developments. Continuing with the morning session, next up is the fundamental topic of mutual trust, when we will be in the capable hands of Professor Cecilia Rizkalna. Her monograph, The Principle of Mutual Trust in European Union Law, is a milestone in academic research on this principle. As the title suggests, Cecilia will touch on the application of this principle in the EEA. In that context, I cannot resist mentioning that recently in the judgment A and B, we held that through their participation in agreements in the area of freedom, security, and justice, the EFTA states and the EU member states have expressed the mutual confidence in the structure and functioning of the legal systems. After the lunch break, we start again with Dr. Dorothea Lexikiewicz from the University of Oxford. The title of her presentation is Interpreting or Reasoning with Law on Two Conceptions, Judicial Authority in EU Law. Reasoning or judicial authority are, of course, fundamental to any court of law. And I very much look forward to hear Dorothea's thoughts on this vital subject. Then it is the turn of Dr. George Bauer, whose presentation is titled The EU Association Agreement with Andorra and San Marino. In what way is it EA plus? I assume that the title draws on the comments of Commissioner Šefčovič, who labeled this proposed agreement EA+. I'm sure that Dr. Bauer will enlighten us on the pluses and minuses of this agreement compared to the EA agreement. Finally, it is with particular pleasure that I mention the final item on our agenda for today. Professor Ola Mestad was an ad hoc judge at the EFTA Court for almost 20 years and has now stepped down from that post. I therefore find it most appropriate that he will end our conference by offering us his thought on the status of the EEA agreement and perhaps also the EFTA Court. Ladies and gentlemen, I thank you very much for your attention and I wish you all a fruitful conference. I will now hand over to my colleague, Mikael Raedsen, who will moderate proceedings this morning.
Now, thank you, and welcome to you all also from me. Before I will say a few more words about our keynote speaker, Takis Tridimas, and introduce him, I have one piece of practical information, and that is something important, and that is that unfortunately the restrooms on this floor stopped working last night, and they haven't been fixed until this morning. But rest assured, there are enough restrooms in this building. So what you have to do is that you have to go one floor upstairs, take the stairs or take the elevator, and there are ample of restrooms upstairs. So now you know. Okay, from restrooms to Takis Tridimas. It's not a very good comparison, I know, because as the president said, Takis Tridimas is one of those rare persons who doesn't really need an introduction. But I am going to give an introduction anyhow, not least because I think he deserves it. And Takis has worked both with EU law over many years, and he's done so both from a practical and from an academic perspective. You started out, Takis, as a clerk early in your career for Advocate General Sir Francis Jacob, who we all, of course, know as well. And in the middle of the 90s or early 90s, and then to the mid 90s. And you have also, of course, been very central when it came to the 10 new member states that came to the European Union in 2003, where you were the chairman of the committee set out by the EU Council to negotiate that agreement in your capacity as a senior legal advisor for the EU presidency. And you are also a barrister. Imagine that. And of England and Wales, and if I understand it correctly, also in the Bar of Athens, and that has allowed you to litigate a number of cases for the European Court of Justice and for the General Court, for the European Court of Human Rights, and for international arbitration tribunals and national courts. Now, but most of us know Takis Tridimas as a leading scholar of EU law, and maybe mostly as a professor at King's College in London, and at the Queen Mary College also in London for a period of over 20 years, if I'm correct. And you have also been connected to a number of universities around the world, in particular in the US, which we also are going to hear about today, about your experiences from the US. But now, you have returned to the heart of Europe, to Luxembourg, as a professor and the founding director of the Center for European Law at the University of Luxembourg, and of which we all are extremely happy, I would say, and which we hope to, and I'm sure that we will, benefit in the coming years. I just recently downstairs had a look at the internet, and I saw this fabulous conference that you are organizing in October on the I can't remember the date, but you say so now. You have the opportunity to do so afterwards on the values of the EUA 2 days conference in October, and it's of course a topic that is extremely important these days, and which we also are going to hear more about here today. I think I would dare to say. Now, the title of your lecture has already been introduced, but I'm going to repeat it again. It's the many phases of an internal market, lessons from Europe and beyond. The floor is soon yours, Takis, but just let me say to you, there will be ample of time for questions and discussion afterwards. We will sit down here and we will take questions from the audience, so don't be afraid to ask questions and discuss with us. The floor is yours, Takis.
Thank you very, very much. I take the floor with great pleasure and a lot of trepidation, given the distinguished audience. Thank you very much for the introduction. I think the message going through my CV is that I do a lot of things badly. I think that is really the essence of this. It is once more a great honor to be here, and I thank the President, I thank the organizers for the invitation. What I thought I would share with you are some reflections on the concept of the internal market and the value of free trade as a constitutional value. So I was going to talk a bit about positive and negative integration as it is understood in European Union law and by extension in the context of the EEA agreement, and then look a bit at some comparative elements, focusing mostly in the law of the United States, but also selectively in the law of Australia and Canada. So one could identify several models of an internal market depending on the nature of its normative underpinnings. Under an international law model, the removal of fiscal and non-fiscal barriers to trade between nations is subject to the disciplines of international law. A prime example here would be the WTO agreement or free trade agreements which are concluded on a bilateral basis. There is a second model, which I would call a supranational model, where free trade among the participating states is effected through a system of rules of advanced sophistication, advanced breadth and intensity that may grant them a quasi-constitutional character. The prime example here is the European Union and, by extension, the EEA. Excuse me. Under a federal model, the constitution of a federal state contains free trade commands. And finally, under a national law paradigm, domestic law may provide for internal market across different regions of a sovereign nation. An example of this is provided by the United Kingdom Internal Market Act of 2020, a post-Brexit piece of legislation which sought to ensure the free flow of goods and services across the United Kingdom and limit the centrifugal forces resulting from the powers of the devolved administrations in Scotland and Wales, which were to some extent empowered by Brexit. So wide variations exist within each of those models, and sometimes, owing to the distinct features and specific arrangements, it may be difficult to draw clear boundaries between them. What I'm going to focus on are the EU and mostly United States law, but also with some reflections on Canadian and Australian law. Now, a comparison, I appreciate, encounters important methodological difficulties. The United States, Australia, Canada are fully fledged federal systems. their constitutional identity morphed over a period of more than 200 years, whilst the European Union is a very young organization, and it is a product of international law, as it is not a federal state, as the German Federal Constitutional Court put it. The EU is a union of states, not a federal state, and its system of governance varies widely. Also, the EU internal market is much younger in terms of age. But I think that these differences do not deny the value of the comparative exercise. A backdrop of commonality exists, which makes the analysis worthwhile. The systems that I am seeking to compare allocate political power and legal competence to different levels of government. Their economies are meaningfully comparable in terms of size, although I don't want to take you through specific data. They all embrace a free market economy and a set of fundamental values based on democracy, fundamental rights, and the rule of law. Differences between them, wide and unfortunately widening as they are, do not deny, to my mind, the worthiness of the exercise. So the EU internal market is based on the twin pillars of negative and positive integration. Negative integration contains a series of negative commands on the member states, not to impede the free movement of goods, persons, services, and capital. Member states, in other words, must abstain from restricting free trade. Positive integration, on the other hand, is pursued by vesting the European Union with authority to adopt measures to facilitate the establishment and the functioning of the internal market. The key provision here is, of course, Article 114. The Constitution of the United States finds in the Commerce Clause an empowering provision similar to that of Article 114, but lacks specific clauses requiring the states to allow free movement. This void is filled by case law, the judicially developed principle of the Dormant Commerce Clause, to which I will come. The Constitution of Australia, by contrast, has both a Commerce Clause empowering the federal legislature to act to facilitate free trade, and commands requiring the states to allow trade to be free. The Canadian Constitution also empowers the Parliament of Canada to legislate for the regulation of trade and commerce. Let me, and I will come to those selectively, let me first provide an outline of Article 114, and I think it is worth revisiting. It is, of course, well known that one of the ways in which the European Court of Justice has contributed to the empowerment of the European Union has been through an expansive interpretation of EU competence. And nowhere is this more evident than in the interpretation of Article 114. There are very few cases where the Court of Justice has found a measure to be beyond the competence of the EU. In the context of Article 114, it is only the first tobacco advertising case. So judicial restraint has empowered legislative activism. Let's take a moment to look at the formula of Article 114. According to the case law, Article 114, which allows the EU to pursue the harmonization of national laws, may be activated where two conditions are fulfilled. There are differences in the laws of the member states, and secondly, these differences either obstruct the fundamental freedoms and thus have a direct effect on the functioning of the internal market, or cause significant distortions of competition. Now, this second limb of the second condition, that differences in national laws must cause significant distortions in the conditions of competition, has actually somewhat been forgotten. It has atrophied. It was used in earlier case law, but more recent case law does not really even refer to that condition. So the key is first to establish that there are differences among national laws, and secondly, that these give rise to a direct obstacle to trade. The truth is that the first condition, that there are differences in national laws, is presumed to exist, because when national parliaments legislate, they do so in order to take, in order to give effect to national objectives. In fact, although the Commission in some cases looks at the differences among national laws, the case law is the court in its reasoning is not particularly preoccupied with that condition. The second condition is the most important one. In other words, whether these differences give rise to a direct obstacle to free trade. Note here that there is no de minimis requirement. There is no requirement that the obstacles to trade must be substantial. In contrast to the distortions in the conditions of competition, which under the case law must be significant, there is no express de minimis requirement in relation to the obstacles to trade. This broadens the EU's harmonization remit. And in any event, if we take the case law, the formulation of the court literally, the formula used consistently by the Court of Justice states that as long as disparities among national laws obstruct fundamental freedoms, that suffices to activate the harmonization power of the European Union, because such obstruction has a direct effect on the functioning of the internal market. There is, in other words, no separate requirement that the obstacle to free movement must, in addition, affect directly the functioning of the internal market. And this condition is not particularly it's not a particularly rigorous filtering mechanism. The standard of judicial review is not strict, and in its interventions, the Court of Justice is minded to facilitate rather than inhibit a broad understanding of EU powers. This contrasts, for example, with the test employed by the Court of Justice to define the scope of the common commercial policy as an exclusive EU competence. The case law there rejects a mere effects-based test and requires that to fall within the common commercial policy, an EU act must relate specifically to trade with third states, and it must be intended to promote such trade and have direct and immediate effects on it. So the most distinct feature of Article 114 is that it provides a transversal harmonization power which to a good extent is value neutral, provided that there are differences among national laws and they lead to obstacles to free movement. The European Union is empowered to adopt harmonization legislation, but retains enormous discretion as to its content. This has enabled the EU to pursue, for example, health protection policy as a secondary substantive objective, even though it lacks power to harmonize the national laws on public health. So the existence of disparities among national laws opens the door for the Union to pursue substantive policies, a process which is assisted by highly selective judicial standard. And in recent years, Article 114 has been used for all sorts of different purposes. In no other era of EU law has Article 114 covered such a breadth of policies. It has been used to promote sustainability and environmental protection, industrial policy, to regulate technological innovation, safeguard EU strategic autonomy, and even counter threats to democracy. Sometimes it is used in combination with other legal bases, but the bottom line remains that it has an extremely wide breadth. In the tobacco the tobacco advertising case, the Court of Justice, back at the beginning of the 2000s, drew a distinction between measures seeking to facilitate the functioning of the internal market, on the one hand, and measures that regulate the internal market. The EU is allowed to do the first, but not the second. But it seems to me that the distinction between establishing and facilitating the functioning of the market and regulating the market is very thin indeed. And since the judgment in Vodafone, in fact, it has ceased to exist. In other words, the tobacco advertising case did not signal a deceleration of the integration project. It was rather an aberration. The issue here, you may recall, was that the European Union adopted a directive prohibiting the advertisement and sponsorship of tobacco products. The court found that the directive overreached because it prohibited advertising in relation to some products where there was no free movement, the so-called static advertising media, such as parasols or ashtrays. But in Vodafone, some years later, the Court of Justice, in fact, authorized the European Union to impose limits on roaming charges by corporations. Essentially, the judgment in Vodafone suggests that if there is a market failure, or if the Commission and the Council convince the court that there is a market failure, then the EU can intervene to regulate maximum prices. Another aspect of Article 114 is that it can also lead to institution building. In two cases, in ENISA and ESMA, the court held that the harmonization clause can be used not only to coordinate national laws, in other words, to bring about the same results by making national laws similar, but also to establish EU agencies, and in ESMA, to establish an agency that can adopt both measures of general application and individual measures. Article 114 is impressive in its breadth, and in recent years, I would say its use is qualitatively different in the following way. In earlier years of EU law, the approximation quality of Union acts was more pronounced. The Council and the Parliament would intervene to bring closer areas of law where there was already an established body of national regulation, for example, in the field of company law. But as times have progressed and rules have to be introduced to address new problems, the EU may intervene in circumstances where national laws in a particular area are less developed or not developed at all. The EU, therefore, intervenes as the first in time regulator, as the principal regulator in an area, often with comprehensive legislation. As a result, the regulatory character of EU measures is at least as pronounced, if not more pronounced, as the harmonization character. Look at the Digital Services Act, for example. Look at the AI Act, and so on, so forth. So it is the EU really that pursues the law reform. So what then happens in the United States? Well, the Commerce Clause of the US Constitution enables Congress to pass legislation to regulate trade among several states. The provision is overwhelming in its simplicity. But when we look at it, I think we need to bear in mind 2 or 3 things. First of all, that the Commerce Clause, the power of the Congress to regulate interstate trade, must be interpreted in the light of the system of governance established by the Constitution, which is based on the principle of enumerated powers. Just as in the European Union, in the United States, the presumption of power lies with the states. The federal government only has those powers which are given to it by the Constitution. By default, power lies at the lower level. Secondly, and most importantly, to determine the true extent of congressional powers, one should not look just at the Commerce Clause in isolation, but examine the totality of the legal basis provided by the Constitution. A very narrow interpretation of the Commerce Clause does not give the full picture, because Congress may do a lot of things under different clauses. And thirdly, the interpretation of the Commerce Clause has evolved considerably. It really was started to be used in the late 19th century, and that coincides with the industrialization of the country. Between the 1880s and the 1930s, the Supreme Court relied on whether an activity had a direct or indirect effect on interstate commerce. If it had a direct effect on interstate commerce, Congress could regulate it. If it did not do so, Congress could not. So manufacturing, for example, was out of reach. The conditions that goods must meet to be put into circulation was out of the reach of Congress, as it was thought to relate not to trade, but to the making of a product. This changed in the 1930s, where the Supreme Court began to adopt a different test, namely whether an activity had a substantial effect on trade. So, just to see the test followed by the Supreme Court, essentially Congress can regulate 3 things under the Commerce Clause: the use of the channels of interstate commerce, for example, roads; the instrumentalities of interstate commerce, for example, aircraft, the conditions that aircraft must fulfill; and thirdly, and this is the most controversial, activities that substantially affect interstate commerce. So when might an activity do that? The locus classicus here of the case law is the iconic Wickard and Filburn case, decided in 1942. There, a farmer in Ohio had produced a higher quantity of wheat than allowed under the Agricultural Adjustment Act, a congressional statute which had introduced essentially quotas on the production of wheat to stabilize the market. He was prosecuted for exceeding his quota, but he argued that the act, in fact, could not regulate what he was doing, because he produced excess wheat for his personal consumption. He did not put it into the market. Therefore, he argued it did not have an effect on interstate trade. But the Supreme Court famously rejected the argument on the ground that growing wheat for home consumption affects the market. First, it enabled Mr. Philbin to avoid purchasing in the market, therefore it affected demand. Secondly, if prices went higher, he would be well tempted to put it into the market rather than use it for his personal consumption. And although his individual production would make no difference, the court says the cumulative effect would have a substantial effect on trade. If every farmer was allowed to do that, that would have an effect on trade. Now, this was a judgment where essentially the Supreme Court decides that even a local activity may be regulated by Congress on the basis of the interstate clause. And until 1995, the Supreme Court had never invalidated a congressional statute. The difference in the tide came in the Lopez case, where a challenge was made to the Gun-Free Schools Zones Act, which essentially makes it a criminal offense to possess a firearm in a school zone. In a nutshell, you cannot go to school with your bazooka. Well, Mr. Lopez did. He was prosecuted, and he argued that the congressional act which formed the basis of his prosecution was beyond Congress's power under the under the Interstate Commerce Clause. And the Supreme Court entertained his claim on the basis, at least as I understand it, of three arguments. First, it said the prohibition is a criminal statute which has nothing to do with commerce or an economic activity. Secondly, in contrast to the Wickard case, the prohibition was not an essential part of a larger regulation of economic activity. And thirdly, it contained, the statute contained no jurisdictional element that would ensure on a case-by-case inquiry that the possession of a firearm had the requisite nexus with interstate commerce. This changed the tide. There have been some other cases where where Congress acts were invalidated. But if you look at what happens in the aftermath of the case, despite the Supreme Court's rebuke, Congress largely got its way. As I said earlier, one of the concerns of the Supreme Court, one of the grounds on which the act was found to be beyond the scope of the Commerce Clause is that the prohibition of possessing firearms in school zones did not contain a jurisdictional element to link gun possession with interstate commerce. So Congress reenacts the statute and amends the key provision to read as follows, I quote, "It shall be unlawful for any individual knowingly to possess a firearm that has moved in or that otherwise affects interstate commerce." And this has survived. To my knowledge, there has never been a successful challenge against this provision. So if you look at it in this context, all that the Congress did was to add essentially a jurisdictional clause. Viewed in this way, the intervention of the Supreme Court is really purely procedural rather than substantive. Allow me to discuss one more judgment of the Supreme Court, and this is the so-called Obamacare case, National Federation of Independent Business versus Sebelius, which has to do with health insurance. In 2010, Congress passed an act, one of the key provisions of which was the so-called individual mandate. Essentially, with a view to increasing health provision, the act required most individuals to buy health insurance, to maintain a minimum of health insurance. And those who refused had to pay a penalty. The Supreme Court found that the Act could not be founded on the Commerce Clause. It argued that the Commerce Clause authorizes Congress to regulate commerce which presupposes the existence of a commercial activity to be regulated. By contrast, the obligation to buy insurance did not regulate an existing commercial activity, but required individuals to contract. In the view of the majority of the Supreme Court, this was well beyond the powers of Congress. The case is, I think, remarkable for two reasons for our purposes. The first is the actual outcome. The Supreme Court says, well, however, because if you don't buy insurance, you have to pay a penalty. This is a tax, so Congress can adopt the Act on the basis of the taxing power in the Constitution. So we hold it valid, but on a different legal basis. Now, this, of course, in the EU context would not be possible. It is not possible for the Court of Justice to choose the legal basis. The court, in its reasoning, would essentially invite the institutions, if they so wished, to reenact a directive or a regulation on a different legal basis. The second reason why the case is important is because, at least to my mind, it takes a very narrow view of a Commerce Clause. This distinction between activity and inactivity does not appear to me to make economic sense, and I don't think it would be followed by the European Court of Justice. But the bottom line is that the activity which is being regulated is the medical services, the reception of medical services. And the truth is that even uninsured people in the United States have to receive a minimum of health care. This is because there are ethical obligations on doctors, ethical obligations on hospitals, and also statutory provisions on hospitals which require them to provide a minimum medical service. So to the extent that the medical service is an activity which every individual at some point in their lives will have to engage in, the distinction between the narrow distinction between activity and inactivity appears to me not to be convincing. In fact, economically, the measure makes perfect sense because what happens in practice is hospitals treat those who are uninsured, and how do they recover the costs? By increasing the premiums that insurance companies charge those that do pay insurance. This is the latest a case of the Supreme Court on the Commerce Clause, but there are cases simmering at a lower level. The issue in the United States is politically hot. In a case which was decided in Texas, Hobby Distillers Association versus Alcohol and Tobacco Tax and Trade Bureau, a district court of Texas challenged the authority of Congress to regulate commercial activities, taking a very narrow view of the substantial effects doctrine. Essentially, a federal statute prohibits the home distillation of alcohol for personal consumption. Now, on the basis of the Wickard case, this would be well within the powers of Congress, but a Texan court has actually invalidated the act, and the case is currently pending before a court of appeal. What would be then some analogies with EU law? Well, the tests are seemingly different. The test that the Court of Justice uses in the context of Article 114 appears to be more liberal than the test that the Supreme Court uses in the context of the Commerce Clause. But a closer examination of the facts, I think, might give us a more nuanced picture. Would it be possible, leaving aside other differences, would it be possible for the EU to impose an obligation on individuals to contract? The answer to that is yes. The motor insurance directives require individuals to purchase automobile insurance. One can draw perhaps some differences, but the point I'm making is that in principle, the distinction between activity and inactivity drawn by the Supreme Court, I don't think is accepted in EU law, and in that sense, the EU law test is wider. But if you look at the facts of the case in the Obamacare, I'm not sure that the EU could require medical insurance to be purchased, because the obvious issue here is that the European Union does not have power in the field of, or at least such power of such intensity in the field of health protection. So there is a bit of a paradox. Whilst the test applied by the Court of Justice is more liberal, the specific legislative choice, I think, would be hard for the EU to make on the facts. The standard of review appears to be similar, but I think we need to be very careful here. Similar in the following sense. The Supreme Court applies what it calls a rationality standard. In other words, it examines whether it was rational for Congress to consider that there is a substantial effect on trade. As it was put in the case of Gonzalez and Reich, in assessing the scope of the authority of Congress under the Commerce Clause, we stress that the task before us is a modest one. We need not determine whether the activities in question substantially affect interstate commerce, but only whether a rational basis exists for so concluding. Or, as Justice Stevens put it in the same case, we have never required Congress to legislate with scientific exactitude. This is a reminiscent of the manifest error test that the Court of Justice follows. So all these cases where the Supreme Court invalidated congressional legislation are cases where, in the view of the majority, Congress has acted irrationally. But if you look at the view of the minority in those cases, they apply the same test, and they come to the conclusion that Congress has acted manifestly rationally, as one of the judges put it. So the actual test followed, I think, does not give us the full picture. There is another difference which is perhaps easier to spot, and this is the requirement of reasoning. In EU law, even legislative measures have to be accompanied by a statement of reasons. This is not so in the United States, where Congress does not have to provide legislative findings. The Supreme Court says, well, a statement of reasons helps, but it's not necessary, and it can be provided ex post. The Congress, during the litigation, can argue, can bring impact assessments and explain its reasoning. What about the Lopez case? Could the EU prohibit the possession of firearms? Well, there is a firearms directive. It has gone through several iterations, and each version of the directive makes the control of firearms tighter and tighter. The latest iteration of it was challenged by the Czech Republic, who argued that, in fact, the directive cannot find a good legal basis in Article 114 because it seeks to protect public security, not to facilitate interstate trade. The Court of Justice did not entertain the argument. Quite to the contrary, it said that the control of firearms generates greater mutual confidence between member states in the field of protection and persons, and therefore contributes to the abolition of controls on the free movement of persons and the transportation of goods. So, conceivably, and assuming that some firearms were legal, conceivably the EU could restrict their possession in certain areas which are where there is an interstate element present, for example, prohibiting the sale or even perhaps the use or possession of firearms in venues where citizens from different member states are more likely to gather, or for example in sporting events or in border areas or even in schools that are likely to have a number of students and citizens from various member states. So I think that despite the difference in the tests, if we look at the actual outcomes, I think there is an oxymoron. What we have is a much less perfect structure, the European Union, much less perfect in terms of federal standards, which in fact gives greater power to its legislature than what happens in the United States. Allow me to move and say a few words about restrictions on trade by member states, by the constituent parts of the federal entity. So moving from positive to negative integration. As I said earlier, in the United States, there is no provision similar to the free movement of goods, the prohibition of quantitative restrictions on imports and exports, but the Supreme Court has developed the so-called Dormant Commerce Clause, and essentially this means that the Commerce Clause not only empowers Congress to regulate interstate trade, but by implication also prohibits the individual states from regulating or impeding interstate trade. It is the value of free trade as a constitutional value imposes restrictions on the constituent parts of the federation. And there the Supreme Court has developed a number of tests. The tests broadly correspond to those used by the Court of Justice, but the methodology is somewhat different. And essentially, the Supreme Court has identified three categories of state laws which may be precluded by the Dormant Commerce Clause. First, state laws which facially, that is to say, overtly discriminate against out-of-state commerce. This is direct discrimination. Secondly, state laws which do not discriminate overtly, but indirectly favor local economic interests. And thirdly, and more controversially, state laws which are facially neutral, but unduly burden interstate commerce and do not pass a so-called balancing tests. Allow me to illustrate the operation, the application of these two tests by reference to two cases. The first one appears to be a case of direct discrimination. City of Philadelphia versus New Jersey illustrates the Supreme Court's approach regarding overt discrimination. A statute of New Jersey prohibited the importation of waste from other states. The court found the measure to be incompatible with the Constitution because it affected interstate trade. The court says essentially what the statute does is to isolate the state from a problem which is common to many states by erecting a barrier against the free movement of waste. City of Philadelphia contrasts sharply with the Commission versus Belgium. This is a case where in which the Court of Justice elevated environmental protection to a key public interest that may justify even national measures that differentiate directly on the basis of the origin of a product. You may recall that a Walloon decree prohibited the storage and dumping of waste originating in other EU states or in another region of Belgium. And the Court of Justice recognized that environmental protection could serve as a justification for restricting interstate circulation of waste. But the normative difficulty with this case was that under the case law, laws that introduce a direct difference in treatment can only be justified on the grounds of Article 36 of the Treaty on the Functioning of the European Union, which does not include environmental protection. The Walloon measure, therefore, risked being per se a violation of the free movement of goods. However, the Court of Justice said there was no discrimination because it drew a distinction between domestic waste and imported waste, and also relied on the principle that waste must be disposed as much as possible at source. So sharply incongruous outcomes in City of Philadelphia and Commission versus Belgium, I think they result from two factors. First, the different justification assessments performed by the two courts, and also the fact that the US Supreme Court expressly stated that there is no principle that requires waste to be disposed of at source. A more interesting and difficult to classify case, I think, is Pike versus Bruce Church. This is a case which concerns an Arizona statute which required that melons, cantaloupes grown in Arizona could only be sold if they were packaged in closed standard containers. Now, the trouble with that was that a company tended to transport loose melons, uncrated melons, from Arizona to California, where they had a packaging and processing plant, and they were prohibited from doing so. The Supreme Court came to the conclusion that this, although it was a neutral measure, it applied to quantaloupes whether they were sold in Arizona or in other states, it did not pass the so-called balancing test because it imposed a burden on the commercial enterprise which was not justified by any public interest. And the court says that a measure can be justified if it is non-discriminatory, if it effectuates a legitimate local public interest, and if it produces only incidental effects on interstate commerce. So indistinctly applicable measures are also caught, but in this case, Arizona did not have an interest to prohibit the exportation of uncrated quantaloupes, as the court put it, Arizona here was not complaining because the company was putting the good name of Arizona on an inferior product, but rather because it was not putting the name of Arizona on a product that was in fact well packaged and superior in quality. The classification of this case in EU law, I think, may pose problems. It could be viewed simply as a restriction on the right of establishment, because essentially what the company was prohibited from doing was to operate an establishment in another state to carry on its business. It could be viewed as a measure having equivalent effect on exports, although the test that the court uses for Article 35 is different. It requires discrimination, although recent case law has, in fact, appears, in fact, to be more flexible. But it could also be viewed, in my view, not as simply as a measure. The Arizona statute is not a measure which imposes which has equivalent effect to exports. It is just a prohibition of exports. Insofar as you are prohibited from exporting uncrated quantaloupes to another state, then this is prohibited by Article 35, full stop. It's not even, it's in other words, a quantitative restriction, not a measure having equivalent effect. Allow me to provide a very brief reflections or lessons, if you wish, from Australia. The Australian constitution is similar to that of the United States and the EU in that it grants to the federal government enumerated competencies, and those which are not held by the Commonwealth rest with the states. 2 points to note here. The interpretation of the Commerce Clause in Australia is much narrower than that of the EU and of the and even of the Commerce Clause by the United States Court. But in Australia, it does not appear to be politically sensitive. It does not generate the polarization and political discussions that it tends to generate in the United States. Also, there are other clauses which essentially enable the Commonwealth to do quite a lot. What is more interesting, perhaps, is the negative integration clause of Australia. In other words, the extent to which individual states are prohibited from restricting free trade. This has given rise to a lot of case law, and according to the test employed by the High Court of Australia, a state measure will prohibit it if it is discriminatory and protectionist. Now, on the face of it, this is a very narrow test. But in the way it is interpreted is, in fact, quite broad. Essentially, the court says that a law will be discriminatory if, on its face, subjects interstate trade to a disadvantage, or if the factual operation of law produces such a result, and therefore it confers a competitive advantage on a comparable intrastate trade. So even the truth is, looking at the case law, even indistinctly applicable measures passed by the states can fail this test. There is also an additional requirement, the requirement of protectionism. But again, this is interpreted very somewhat narrowly. A law will be protectionist if it exhibits some kind of favoritism in favor of state products in form or in effect, but it will not be protectionist if it has as its real object the prescription of a standard for a product or a service or a norm of commercial conduct. A key case here, Cole versus Whitfield, where the High Court of Australia upheld a Tasmanian law which prohibited the sale of crayfish beyond a certain size. This essentially disadvantaged imported crayfish, but the court said there was a good conservation reason for doing so, and there was no discernible discriminatory effect. The issue, I'm so sorry. The issue of free trade was revisited more recently in a case called Palmer versus Western Australia. This is a post-COVID case. Mr. Palmer is a wealthy entrepreneur in Australia whose who is who entry lists as his main hobby litigation. So if you are a lawyer, it's really very worth knowing him. The case concerned a challenge against a statute passed by Western Australia, which essentially closed the border during COVID. It was possible to grant an exemption, but Mr. Palmer was refused that exemption, so he challenged the Western Australian prohibition as being against the free trade provision of the Australian Constitution, Section 92. And the case is interesting for two reasons. First of all, because the High Court of Australia for the first time says that the test for determining the lawfulness of a measure is the same whether it imposes a restriction on goods or services or a restriction on persons. The law there imposed the restriction on persons, but traditionally the High Court appeared to follow differential standards. So the judgment appears to bring about a unification of the test in relation to all free movement. The second is because there was an intense discussion in the court as to what is the appropriate test that determines the distinction between lawful and unlawful impediments to free trade. Is it the test of reasonable necessity, a measure, in other words, will survive scrutiny and will be compatible with free trade if it is reasonably necessary, or is the appropriate test the test of structured proportionality, which is essentially the EU version of proportionality. One of the judges referring to it as a foreign jurisprudential pest that unsettles the economy of the Australian legal system. And by a thin majority, the court decides that the structured proportionality test is the appropriate test to follow. There is no difference as to the outcome. All the judges agree that the Western Australia restriction is compatible with the Constitution in view of the health hazard that COVID posed. But in terms of legal reasoning, there is a distinct nuanced difference among the judges. Proportionality wins 3-2, but it is really a quite interesting judgment to look in detail. I don't have time to do this, but to me, there is a lot of misunderstanding as to what the structured proportionality test requires. I think the judges in Commonwealth countries traditionally take issue with the third aspect of proportionality, the so-called stricto sensu proportionality, because they consider that it leads them to make subjective judgments. So in conclusion, I think in federal systems, freedom of interstate trade is elevated to a constitutional value by virtue of the fact that it is both an economic necessity and a political imperative. And it essentially has two elements. One is granting to a federal authority power to regulate interstate trade, and secondly, restricting the power of the constituent parts to impede it. And the survey of the systems that I examined gives us I think, a variety of patterns. I think it is interesting to see that in the EU, as I said earlier, Article 114 has evolved to the main instrument for law reform at EU level, enabling the member states to pursue collectively a diverse range of policies covering economic, social, and industrial security aspects. And essentially, what Article 114 does is to operate as an empty shell that bridges the gap between the capabilities of the Union and the expectations, the political expectations that the member states have from it. The test adopted by the court appears to be less exacting than the test employed by the Australian and the High Court, the United States Supreme Court, and, although I didn't have time to go through it, the Canadian Court. But I think in the EU it has acquired an existentialist character. There is a fear that unless competence is recognized, the EU will be rendered irrelevant. So any question of competence is almost elevated to a question of the raison d'être of the EU. But I think there are other reasons why the Court of Justice is more liberal. I think it may feel that there are other ways in which the member states may protect their interests. Once a measure has been adopted, then a process has been followed. Member states can protect their interests through the legislative process, through informal rules of conduct of unclear normativity, such as the Luxembourg or the Ioannina compromises, which still very much survive. And insofar as it can be presumed that vital national interests are at stake, the EU cannot take action, then the court sees no reason to be more active in protecting member states' interests. Also, there are different paths of dependency. In contrast to its common law counterparts, the ECJ does not see itself as the guarantor of dual sovereignty, but rather as driven by the objectives of the EU. Finally, there is a different stage of integration. Let us not forget that the nationwide market of the United States, Australia, and Canada are a lot more established and advanced. They are in market maintenance stages, whereas the EU is still in a market building stage, as Professor Barnard has put it. Suffice it to say, a recent study, 2024, suggests that intra-EU trade accounts for 26% of the GDP of the collective GDP of the European Union countries, compared to 60% in the United States. EU tax regimes vary considerably, and EU capital markets have a long way to go before becoming fully integrated. Some markets remain very stubbornly national. Only 3% of EU citizens live in a member state other than the state of birth, compared with 25% of US citizens. And the EU institutions perceive perhaps their role as being to contribute towards filling that integration gap. Thank you very much for listening.
Now, thank you, Takis, for a fascinating lecture. I think we have about 15-20 minutes for questions and discussion, and I will very soon open the floor for the audience, but I will allow myself one comment and reflection first, which will end up in a question. And what you have done, Takis, is, of course, you've taken us through a large part of the legislative powers of both the US and the EU and Australia, and you've not only done it at a point of time and how it interacts with courts, and you've not only done it at one point of time, but you've done it through drawing a historical picture and said something about how it's developed and changed, and how courts have gone a bit back and forth, and in doing so, it made me reflect on a quote from one of my favorite judges, one of the former presidents of the European Court of Human Rights, Lucius Wildhaber, who said, "Judges must have regard for the aims which they are serving and the contexts in which they live." And it's this last part here which I'm a bit interested in now, the contexts in which they live. And if you take, for instance, the Obamacare judgment, if I were to be provocative, I could say, well, the reason why that happened as it did was that it was Obama. It was a highly controversial bill in which, you know, the Democrats and the Republicans stood on each side. No Republican voted for the bill, and then you ended up in the Supreme Court, and you found the majority found a way to say that this doesn't fly, and you had examples of sort of similar. You take the context in which you live. The context in Europe is different, and the context these days are different than what it was. I think we all know the times that we are living in now with the US, where we have a president who's sort of passing legislation himself through executive orders, and when he's not doing that, he's doing it through threats. He's regulating the market through threats, and we have a Europe where the ECJ is and the Commission and many others are putting values in the forefront, and are developing Article 2 in the TFEU, and that's meeting a lot of criticism from some member states and conservative parts of Europe, etc. So my question is, where does this leave us with these internal markets as of today? Where can we expect that these courts end up? Is it possible to say something about it on the historical pictures that you have drawn already, and what we've seen, and the context which we are today?
Thank you. Yes. Two comments, I suppose, I would make. One is there is a clear tension in the following sense. The process of adjudication, the process of deciding cases is par excellence a process of rationalization. You try to find a solution, you compromise, you balance different interests, because I think courts do balancing. Even when they say they don't do it, inevitably they do it. I think that's an inherent part of the exercise, because you all agree on principles, but not all of us draw the same outcomes from those principles, and therefore we need intermediaries, and the intermediaries are the courts. It really is much better to fight it in the courtroom than through armed forces. And the main tool is rationalization. The proportionality is it really epitomizes this process of rationalization. Now, the political process, of course, is not rational at all. It has nothing to do with rationality. And this is, to my mind, this is why we need courts, and this is why we need rights. The reason although we discuss free trade, I think the same applies to all sorts of rights. If you don't have rights, then you have an entirely different political system, and you need very strong rights to counterbalance the irrationality of the political decision-making process, and if I may say so, the irrationality of the voting process. Yeah? As a voter, the right to vote is the most, in some respects, the weakest right, because you're just one of many, but in some respects, it's the most powerful right. And it is the most powerful because I can go into the voting booth and I can behave irrationally. I can exploit my worst prejudices and say I'm not voting for him because this person has a certain gender or has a certain ethnicity. All sorts of things you cannot get away with outside the booth. You can get away when you vote. And this is precisely why I need some limits to what the majority can do. And that, I think, applies not only to civil liberties, it also applies to free trade. Free trade is a constitutional value in a liberal society. So I think it is important to have a process of rationalization. I think, in my view, but I stand to be corrected, proportionality is the imperfect but the best way of doing this process of rationalization. I think what I would also say is that sometimes courts, I think there are some limits to how many errors of the decision-making process courts can remedy. They cannot do everything. Judicial review also has its limits. The judiciary is really the least dangerous branch. And as we saw in these cases, the politicians in most of them got most of what they wanted. And an example of these cases is that there is a conversation between the branches of government, but essentially the politicians get most of what they want. So I think we need to be very careful in saying that it's okay to give to the European Union a lot of power because there is judicial review. Judicial review will not undo all the problems of a bad political decision-making. So I'm not sure if I'm answering your question, but I think, yes, there is immense value in recognizing rights. I think that proportionality is the best way of doing it, but I think we should also be aware of the limits the limits of the good that courts can do, as it were.
Very tempting to comment on that, but I will leave it to the audience now. And I look around, and was the one on the front row here? No, that's it. Please state your name and affiliation so that we all know who you are.
My name is Hafstein Kristjansson. I'm a professor at Reykjavik University. And I was wondering, when you used some phrases on the judicial task for Article 114, like liberal, lenient, lack of judicial restraint, whether that, one, reflected a critical attitude towards the test or whether you are in favor of it, and two, if it's critical, do you have any specific example of cases that you think should have been decided differently, and then maybe aside from Vodafone and Czech Republic case?
Thank you. I think my main critique is the one I just expressed. In other words, I read the case law, and I stand to be corrected. I read the case law as meaning the court says, well, it doesn't matter if the EU has broad competence, because you are here to control that. You give more powers to an organization, and correspondingly, you increase the accountability mechanisms, or at least the judicial accountability mechanisms. And I don't think, what I'm saying is, I don't think the increase in a judicial review necessarily can undo all the problems, all the deficiencies of the political decision-making process at EU level. I think we need to be aware of this. However, it doesn't mean I'm necessarily critical of the case law of the court. If anything, even the tobacco case could be decided differently. In the tobacco case, there is a distinct lack of economic evidence. I think it's a response, if you go back to the beginning of the 2000s, there is a critical view towards the powers of the European Union. There is some issue of legitimacy, and I think courts should be aware of the political environment. It's very simple. If it rains, you want to have an umbrella. But if you look at the judgment, what the court says is, okay, if you prohibit advertisement in magazines, then that's okay because there is a lot of interstate trade in The Economist magazine, and therefore you want to have the same version of the magazine throughout the European Union. If the French want to allow advertisements subject to certain warnings, and the Italians want different warnings and all that, you cannot have the same magazine. But the court says that doesn't apply to parasols where you advertise tobacco, or it doesn't apply to ashtrays, where you remember in the old days, ashtrays used to incorporate sometimes an advertisement of a brand of cigarettes. Well, I'm not sure if that stands, because the Hilton chain wants to order ashtrays for all its hotels in Europe. So I'm not convinced that distinction really stands. What I'm saying is that I can take issue with specific aspects of the court's reasoning, but I would not make a statement that the court somehow has overreached in its interpretation of Article 114. I think it is, and I think we need to be, again, very sensitive. It's perfectly all right. We can disagree on specific outcomes, but I think we need to be very careful if we make the argument that the court is illegitimate. I think that that's a very dangerous argument. It has to be, we need to be extremely careful before making these kinds of statements.
There is one at the back.
Keep it very short. Atanas Popov. I'm an academic, and I've recently joined the EFTA Court also. As, Professor Tridimas, your lecture reminded me of a lecture that I attended a very long time ago, 25 years almost. I think it was organized by Sir Francis Jacobs, by a Canadian comparatist. He wasn't Pierre Legrand, he was someone else, who, as in your lecture, drew attention to the fact that he was struck by the fact that the Union had more competence than individual states within a federal system, US and Canada. And so you explained today that competence is the raison d'être of the EU. It's really impressive, but on the other hand, it raises issues with governance issues, because the Union has more competence than a federal state, but without being a federal state. So what kind of solutions are there to this paradox in the long term? Because it was already raised 25 years ago by someone.
Thank you. Well, yeah, I mean, this is a question of as I understand it, of where we go from here. I think the label does not matter. I think it's a fact that the European Union is forced to take action in areas that it was not predicted. So I don't think there is a ground plan of European integration. I think it is a fallacy to think that somehow there is a ground plan of the EU. It could be nice, you know, but unfortunately, we cannot design laws or legal systems from the comfort of the lecture room. I wish we could. A lot depends on what happens on the negotiating table. A lot depends on how things develop. So, for example, on matters of defense, it's very simple. The member states consider that there are a few things which it is in their interest to do collectively than to do individually, and the European Union or structures at the outskirts of the European Union may provide the best mechanisms for doing so. I think the job of the lawyers are to observe certain limits to protect the individual, but also to facilitate the political outcomes that result from democratic processes. So I think where the EU is going, it doesn't, unfortunately, it doesn't depend on the EU. It depends on on its political surroundings.
So then we are back to the context and the aims. One last question, and then we'll finish. In the middle there.
Thank you. My name is Thomas Renchens. I'm a referendaire at the General Court. Towards the end of your lecture, you cautioned us that when we do comparative law between the US and the EU internal market, we're comparing markets that are in market maintenance versus market building mode. Do you have any guidelines for the practicing comparative lawyer, think of a referendaire, who is looking at how case law develops in these other jurisdictions and whether there are perhaps cautionary principles that we should bear in mind, other than that these markets are at a different stage of development?
Interesting. I'm not sure if I have any. I'm not sure if I have any guidance other than to say that personally I would be very open to foreign legal systems to see how they decide similar issues. I think that enriches one's understanding. I wouldn't see it as a threat to our legal tradition, but rather as a way of enriching it. I would also be curious just to see how other people decide similar cases, being, of course, aware of the different political context. So in that sense, I think it's a very good idea to look at what happens in other jurisdictions, but that doesn't mean that there can be a kind of transplant which happens in a vacuum. I think there are some areas, perhaps, where it is easier to borrow than others. It may be the case that commercial law or intellectual property, these are areas where I think it is easier to borrow elements from other legal systems, but even in those aspects that have to do with federalism and constitutionalism, we have a lot to learn.
Thank you, Takis Tridimas. I think we owe you one last round of applause. And then we will have a coffee break, and we'll take it until 11:35, so 25 minutes.
So I promise you that there will be plenty of time to discuss more later on. We are good at breaks. Now, this next session consists of two contributions and two speakers, and we'll do one first and take questions and answers thereafter, and then the next one with questions and answers, and thereafter we will have lunch. And the first speaker out is Niamh Nic Scribner, and she's a professor of EU law at the University of Edinburgh, and a co-director of the Edinburgh European Institute. And I suppose many of us know her as one of the editors of the Common Market Law Review, our favorite law journal. Over a period spanning over almost 30 years, you have published, I think, extensively in EU law, and in particular, I would dare to say the freedom of movement of persons and citizenship law, in which I think it is fair to say that you are one of the leading legal experts in our community. And that is somehow also your team here today, or a branch of it, which you have entitled When Words Are Not Enough, Judging the Free Movement of Persons, which will deal with, I think, but we'll see, how EU citizenship law meets and aligns with the freedom of movement of workers within EEA law. And that has, of course, been one of the most difficult issues that we have had to face in EEA law over the last 15 years or so, and since the inception of the EEA agreement. So we are very much looking forward to receiving your help in this regard. Yeah, but I will just say that, well, okay, we'll have 40 minutes or so, and then we'll have 15 minutes for questions and answers afterwards. So, Niamh, the floor is yours.
Thank you very much. I'm delighted to be here. Thank you to the EFTA Court for the invitation. I would echo what Takis said earlier. For this event, it's a mix of honor and trepidation, especially to talk about this topic. And I would say, though, that I feel I am among friends, because when I sent my title to the EFTA Court colleagues, it was immediately understood that I was referencing perhaps the most important Irish figure of European integration of my childhood, which was, of course, Johnny Logan. So we had some mutual understanding there from the beginning. I would also very much like to acknowledge that I have been extremely lucky in recent years to work with and share ideas with colleagues, particularly at the University of Oslo, where I've spent some time on research leave, and also to have some regular and lively exchange of ideas with Halvard at the University of Bergen. And I think I'm also particularly grateful to all of these colleagues for their patience and their forbearance, because as I move more deeply into understanding the EEA, I basically behave like a 2-year-old, asking constantly, but why? And that is the perspective I am bringing today. I want to ask why. On the topic of the free movement of persons, and specifically, as the title says, when words are not enough. I'll start with the idea of when legislative words are not enough, but I'll move more broadly after that. So just to give a brief overview of what I'm going to talk about, first I'm going to outline the problem. What is the problem? And then I'll consider a little bit how the Court of Justice addresses the EEA dimension in its case law on the free movement of persons. I then turn to the EFTA Court, and indeed the Supreme Court of Norway, given recent case. And I use the language of what the EFTA Court should do very lightly. I'm speaking here today in the role, as academics often refer to themselves, as critical friends, but I hope the emphasis is much more on the friendship than the criticism. So to begin with the legislative words, the problem, as I saw it, to reflect on this for this conference concerns situations where Directive 2004/38 on the free movement of persons either does not cover the facts in question, or it does seem to cover the facts, but other factors, at least on the surface, would distinguish the situation and how it should be resolved under EU law and under the EEA agreement, respectively. Of course, I am referring in particular here to the 2007 Joint Declaration, which states that the concept of citizenship of the Union has no equivalent in the EEA agreement. The declaration also states, as you will know, that residence rights for third country nationals fall outside the scope of the agreement, with the exception of rights granted by the directive to third country nationals who are family members of an EEA national exercising their right to move under the EEA agreement. Now, I mentioned at the beginning that I also want to start by touching on the EU law perspective, and there have been some statements in case law from the Court of Justice suggesting that aspects of the free movement of persons are not, as I've described it in recent work, shareable with the EEA. So, for example, this is a very much discussed statement from the Advocate General in the Nordic Info case. And it asserts that free movement rights stemming solely from Articles 20 and 21 of the TFEU are not applicable within the EEA. Of course, what we then have to ask is, what rights, if any, stem solely from these treaty provisions? I would also distinguish two lines of Court of Justice case law. First, we have many cases on the free movement of persons where the Court of Justice has evoked union citizenship, used union citizenship, to expand the scope of the free movement of persons under EU law. As shown here in the VI case, where we're talking about permanent residence rights and the economic conditions that are removed for permanent residence enjoyed by EU or EEA nationals, but the directive doesn't speak about the conditions with respect to third country family members who also acquire derived permanent residence. The Court of Justice goes to the treaty and the concept of union citizenship to read these same conditions into the directive, even though those words are not in the directive itself. So this is an example of how the Court of Justice uses union citizenship to expand the meaning and the rights of the free movement of persons. But there is a second category of cases, exemplified here by the Siebel case. These cases suggest limitations on shareability of free movement of persons, particularly union citizenship-based free movement of persons, from the perspective of the Court of Justice. Reading this ruling on its own terms, and it's about the provisions of the directive that grant more extensive protection to union citizens, we'll come back to this, to union citizens in situations of proposed expulsion from the host state on grounds of public security and public policy. The language that the court used, and this case was a case regarding the EU's agreement with Turkey, but the language that the court used, the concept of citizenship, of course this has direct resonance with the EEA agreement. And the Court of Justice seems to suggest in the Siebel case, without mentioning Turkey specifically, that certain protections provided by Directive 2004/38 apply and can apply to union citizens only. Now, on the one hand, it is of course reasonable that the Court of Justice, in a case about free movement of persons, with Turkey in this case, will make statements about union citizenship. Of course, that's reasonable. But the directive applies beyond the EU. And I would suggest perhaps practitioners and academics, including myself, of EU law, have not always been sufficiently mindful of the fact that this directive applies beyond the EU. So it is unfortunate, to say the least, that this paragraph exists where we have the directive applying beyond the EU. However, I would also add that, of course, this ruling was delivered in the context of the agreement with Turkey, and before cases such as Ruska Federiska and Alcaster, which Cecilia will talk about in the next session, which talk about this deep, special relationship with Iceland and Norway so far in particular, and to which I'll come back a little bit later on in the presentation. But I would leave the message on this point simply as one of mindfulness for the court across the road. However, a further issue stems directly from the directive itself, and in particular Article 3, Paragraph 1, as well as from the case law of the Court of Justice, which determines that because of the wording of Article 3, Paragraph 1 of the directive, it can only apply when the beneficiary of protection is in the host state. The recent MH case, where we have judgments from the EFTA Court and also the Supreme Court of Norway, is a manifestation of the difficulties that this provision of the directive and its interpretation by the Court of Justice have long posed for EEA states. I'm focusing, of course, in particular here on, from the MH case, situations where someone has exercised freedom of movement but is no longer in the host state when they return to their home state. And also, in particular, where they do not hold the status of worker. So where it is free movement of persons rather than free movement of workers on the facts. These two extracts from the EFTA Court judgment in MH outline two things that I want to discuss in more detail today. First, what the EFTA Court describes as the primary and individual right to move and reside freely within the territory of EEA states. And second, the idea that the directive must be interpreted differently in EEA law in order to realize its objective. Thus, notwithstanding the wording of Article 3 of the directive, the EFTA Court considers that provisions of the directive continue to apply when an EEA national returns to their home state after the exercise of freedom of movement. Let us take a deeper look into these two issues, which are, of course, interconnected. This table illustrates what we might call the genealogy of the right to move and reside in EU law. Directive 93/64 created a right to reside in a host state in situations of economic inactivity, subject to certain conditions on financial resources and comprehensive health insurance. But this directive is rather shy about where the logically prior right to move to the host state actually came from. No right to move is conferred in the main part of the 1990 directive. I might therefore describe it as the original sin of the topic we are considering now. However, in the preamble to the 1990 directive, there are two important references about the right to move. First, that freedom of movement is established as a then community objective. And second, reference to the treaty provision which both defines the internal market and which indicates that measures aimed at progressively establishing that market should be adopted. Now again, the EU treaties have changed, but a provision defining the internal market and a provision suggesting that measures must be adopted progressively to achieve it have a lot of resonance with the agreement, the EEA agreement. In EU law, the Maastricht Treaty, very soon after the adoption of the directive, intervened. We will never know what would have happened in EU law on returning to home states absent economic activity. Article 21 of the TFEU is the source under EU law of what the EFTA Court also refers to as the primary and individual right to move freely. And under EU law, Article 21 of the treaty is the source of this right, irrespective of the purpose or activity undertaken or not undertaken in a host state. Again then, under EU law, the directive merely sets out the conditions governing the exercise of that right for Union citizens and for their family members. Because of the 2007 declaration, the same legal trajectory cannot apply for freedom of movement under the EEA agreement. This table, I think, shows the point. You see, in cases discussed at length in both the EFTA Court judgment and the Supreme Court judgment in MH, Singh and Eind are relatively straightforward in terms of shareability with the EEA because we have the exercise of economic activity in both of these cases. Things get more complicated when the Court of Justice delivers its ruling in ONB, because here the source of the right to move is not the directive because of Article 3 of the directive. The source of the right to move is Article 21 of the TFEU. What the Court of Justice then does is say that while the source of the right to move and reside in this return to the home state situation is Article 21 of the treaty, we can apply the provisions of the directive about conditions and limits by analogy. But the Court of Justice is very clear in this case and subsequent case law that it is not applying the directive. In MH, the Norwegian Supreme Court, somewhat vaguely, in my view, refers to the directive as the basis for the right to move for economically inactive persons. So the directive does two things in EU law. It sets out the conditions governing the exercise of the right to move, and it guides primary rights that are applicable in return situations, but only by analogy. It seems to me, reading the MH case, or particularly the judgment of the Norwegian Supreme Court, that the directive is doing three things in EEA law. In addition to the conditions governing the exercise of the right in a host state, and to guiding rights applicable by analogy, it seems for the Supreme Court also to be the source of the right to move and reside in the first place. But the Supreme Court does not refer, in paragraph 96, to specific provisions of the directive to tell us where that right comes from. We saw earlier that the EFTA Court has spoken a bit differently from the Supreme Court, the primary and individual right to move and reside. But I must also ask, where does that right come from? What is its source in EEA law? I very much appreciate that the primary and individual right language has evolved over a series of EFTA court cases on freedom of movement where there is no economic activity, but I must confess, nevertheless, a more extended discussion of the basis of the right. Similarly, if both the EFTA court and the EEA state national courts at different times have spoken about applying the provisions of the directive in this situation, why do we not apply Article 3? As I've mentioned, in EU law, things are different. And I would suggest that the Court of Justice has used three main methods, deepening over time, to progress the free movement of persons. It has used scheme, status, and system. For scheme, I mean significant use of general principles of law, such as effectiveness of rights. Status, for the specific context of not economic activity, the Court of Justice has engaged union citizenship since Maastricht. For system, I mean the broader terrain of the EU legal order, the values referenced in Article 2 of the Treaty on European Union, the more structural principles of the EU and its law, such as direct effect and mutual trust, which the Court of Justice, in fact, is referring to more and more in its recent citizenship case law. Can this scheme, status, system approach find resonance for the case law of the EFTA Court? I would suggest that the scheme of freedom of movement is where the case law of the two courts overlaps most strongly. We see so many references now to, for example, the principle of effectiveness in EFTA court case law. And of course, homogeneity, such a vital principle in the scheme of the EEA agreement specifically. Citizenship status cannot play a part in freedom of movement under the EEA agreement, as I have discussed, and I think we can accept. But what I want to suggest today is that it is perhaps how the EFTA court might further develop the system of the EEA agreement that might be crucial in the next phase of development. How should the EFTA court develop that system? That is most definitely not for me to say. However, I know that debates continue within EEA scholarship about what the agreement says and what the agreement does not say, about the source, the place, and the force of unwritten principles of specifically EEA law. But I will say a little bit about what this friendly outsider sees looking into this special system. I would first turn my own question around and suggest to you that perhaps words are enough. Not the words of the directive, but the words of the EEA agreement itself, where a commitment is plainly made to the fullest possible realization of freedom of movement through the creation of an area that is dynamic as much as it is homogeneous. And this area is based on long-standing common values that we share with the EU and its member states as well. The Norwegian Supreme Court characterized the step taken in MH as a minor legal development, but not a significant leap. Respectfully, I disagree. At the same time, I do understand why the Supreme Court framed the case in that way. In EU law, we speak constantly about judicial activism and judicial overreach in terms of both creating and sustaining the EU system. But let us not forget, it was the EU member states who conceived the language of the EU's specific and essential characteristics in setting down red lines with respect to EU accession to the ECHR. Yes, the court has done a lot with those words, but it is the member states who set that declaration down. We see in EEA law and EU law much discussion of sovereignty of states. But membership of the EEA is, in my view, an exercise and expression of sovereign choice. It is not imposed. It is voluntary, to borrow from the Court of Justice on the Whiteman case. If you push too far that membership is involuntary, you end up just like the country where I reside. I would caution against it. As many in this room have emphasized in their own work, the contracting parties to the agreement have responsibilities to progress the system that the EEA agreement, in my view, clearly produces. Perhaps acknowledging that would be a first step. Judicial words, however, are also words. They are legal words, moreover. As the friendly outsider looking in, I see tantalizing glimpses of the EEA system in the case law of the EFTA Court. This court has touched, often very delicately, on general principles of EEA law, on synergies with the EU Charter of Fundamental Rights as well as the ECHR, on the special and distinct qualities of the EEA agreement as an international agreement, because that agreement is premised on a mutually, politically and judicially acknowledged special relationship. That relationship is described by the Court of Justice and the EFTA Court as going beyond the internal market. As I've already mentioned, for this topic, the EFTA Court speaks about primary and individual rights. Sometimes I would suggest rather elusively, sometimes with reference to the directive, sometimes with reference to Article 1, Paragraph 2 of the EEA agreement. These statements are more frequent, and in my view, they're getting stronger. Strong statements need both wide and deep systemic roots. As the friendly and curious outsider, I fully realize it is very easy for me to stand here and ask for more systemic development, for the drawing together of these threads to articulate more fully the nature and the implications of this truly special system. But I would caution too that sometimes holding back causes more problems than pushing forwards. In the free movement of persons, for example, holding back seems to attribute legal obligations to legislative words that, to my eyes, just do not support them, cannot support them. I leave you with this image, which I took just around the corner on my last visit to Luxembourg, to your neighboring court. These trees are separate, but they are bound together. I would suggest for the EEA that both the separation and the bondedness matter. And people will see and derive different things from this image. But I will conclude this morning with what I see. What I see is for the persons who stand under those trees, greater shelter. Thank you.
So thank you ever so much, Niamh, both for your messages to court on the other side of the street, then the messages to this court. I am going to be careful on commenting on concrete examples of case law. I think there are other persons in this room who can do that more appropriately and maybe more freely than I can. What I will say is something generally about how courts, and in particular international courts, tend to develop rights, and mostly they do so on a case-by-case basis. Small steps, and then at some point of time you end up with a principle. And I think that has been visible also in the case law of the ECJ, even though they very early were brave and put out the principles of direct effect and primacy of EU law. It wasn't really before in the 80s maybe that they really started to develop principles which Takis Tridimas has explained eloquently in his fabulous book on the general principles of EU law, which came in 99 or beginning of the 2000s, I can't remember correctly, but still. So that's principles step by step, usually by courts. And in that regard, I just wanted to mention maybe what is the last step in this history from the EFTA court, without really saying all too much more about it. And that is that after the MH judgment in case E2324 of the EFTA court, which is called AO and IM, and which came about approximately 2 weeks before the Supreme Court rendered its judgment in MH. What the EFTA court did in that judgment was that it, for the first time really in these kind of cases, referred to Article 1.2 letter B in the EEA agreement and connected it to Recital 5 in the EEA agreement. And I think it's worth just reading that out, what it says. If I can find it, so recitals. Recital 5 says quite generally, determined to provide for the fullest possible realization of the free movement of goods, persons in general. It's not talking about workers, it's talking about persons, and it's not talking about being economically active or being economically inactive, and it's not talking about home state or another state, but it talks generally about determined to provide for the fullest possible realization of the free movement of goods, persons and services, etc. And Article 1.2b also refers generally to the free movement of persons and not only workers and whether you are economically active or inactive. And so I would just like to say before this 23-24 judgment, the emphasis had much been on the directive and had to be interpreted differently, etc., etc. And so this is the first time the court has referred to this, and what kind of meaning it has. We will have to see for the future. But I noticed that the Supreme Court in its MH judgment didn't refer to that recital in that paragraph. So you can comment on it if you want. If not, I think we will open up on questions from the audience.
I would just say that, as I mentioned, this is exactly the language that we had in the 1990 treaty and then directive. So even though the directive was repealed and replaced, the agreement was not. So I wouldn't be shy about using this because it's simply the words of the agreement.
Yes, please state your name and your affiliation, please.
Yeah, my name is Ola Risberg Hannesson, working as a legal secretary for the EFTA court. You discussed a lot about the M8 judgment, but I think also we have to see that in its context, because before the MH judgment there have been a lot of cases discussing the directive and its application to the home state, and especially in the case prior to MH in Campbell, it went into detail into the fact that, like you mentioned, principle of effectiveness. And what does the principle of effectiveness mean in the EEA? Of course, principle of effectiveness applies very differently in the EEA than in the EU, because there are we do not have Article 20 or Article 21. And you can speculate how the ECJ would have interpreted Directive 2004/38 and Article 7 if, similar to the 4 freedom cases and the Article 21 cases, the home state is restricting the person's rights in the host state. And like the ECJ has often said, that if the home state is restricting the person from having rights in the host state, that right is brought to a naught. So we can speculate, if Article 21 would not exist in the EU, how would then the ECJ interpret the directive and Article 7? And you can see, for example, that in the McCarthy case, the Advocate General was very adamant that it made no sense to apply it by analogy, that the directive should be applied. So the EFTA Court has actually been very clear on the fact that Article 7 is the source of the right. It has not been, there's no question about that. It's not applied by analogy to Article 21, which doesn't exist in the agreement. The source of the right is Article 7, and the source of the right derives from the fact that the right of Article 7 is precluded if the home state can preclude it. So that was the reasoning of the EFTA Court.
Do you want to comment on it? Or?
Well, I can just say very briefly, I mean, I fully accept what you say and the outcome. And I also think, had Article 21 not happened, we would be in the same place by some means. But of course, we wouldn't have Directive 2004/38 if Article 21 hadn't happened. We'd have a slightly different updating of the 1990 directives. It's unavoidable that citizenship has played a strong role in the legislative process of the creation of the directive. And I would hope that in what I've said, part of the problem is not the EFTA Court, it's the provisions of the directive itself, because of the predominance of language of host state, even though the Singh case predated the adoption and negotiation of the directive, even though the Eind case, so knowing this, knowing that return situations were part of this, it's a poorly drafted measure when the EEA context is taken into account. And I hope I've also made clear that part of the problem here is your neighbouring court perhaps just not being mindful that this must play out in a context that, of course, includes union citizenship for many parties to the EE agreement, but not all of them. And so mindfulness of that, I think, is crucially important. So I would suggest your court has had the more difficult job as a result of that case law and the drafting of the directive.
Other questions? No reason to be shy. Yes, please.
Yes, hello. My name is Per, and I'm the legal secretary of Michael. Yeah, it's interesting to see that all the referenders are commenting on this. I just want to challenge you a bit on maybe the wording. Like, for instance, you have under primary law, you have the provisions on freedom of movement. And they often also focus on host state restrictions. And still, in the very beginning, the ECJ said that, well, if you're going to have an effective host state freedom of movement, you're going to also have to include the home state. So is it really a big problem with the directive? That's the perhaps a bit leading question. But yeah, thank you.
I think, again, it's a problem if you keep, I mean you, broader than you, one person, of course, if you keep insisting that the directive alone can be read in this way, then to go back to Takis's language, to the rational reader of the directive, I would suggest it cannot. But there is an agreement where, as you've read for us, of course it can be read in that way. Of course it can. So I think it's more the sort of illusion that the directive is enough to cover all of these situations, even if we say it must, and I agree, be applied and interpreted differently in the EEA context. I do think that to insist, and I know your court does not so much anymore, but other courts do, that the directive covers these situations, to me, it's too easy to counter-argue. The wording of the agreement, to me, is wider, deeper, and more difficult to counter-argue on these situations. So I have no problem with the concept of the deterrent effect idea for an internal market that aims for the fullest possible realization of the free movement of, as you pointed out, persons. And I do think it is important for the contracting state parties to accept that this is the promise and the commitment. And again, I know it's easy for me to sit here and say that, but the world around us is falling apart. Rules-based orders are vital, and these rules are plainly seen in the wording of the agreement, in my mind. So I would just caution not to insist so much that they're in the wording of the directive, because it's a different measure. It's designed with the primary rights behind it. So I think the agreement contains the words that are needed.
One last question from the audience, please.
Yeah, Halvard Haukeland Fredriksen, University of Bergen. Great speech, many thanks. I really liked your point about the original sin. I'm not sure if I agree completely as to the interpretation of the 1990 directive, but we could leave that for another time. But the original sin in the EEA setting, isn't that implementing the directive and not acknowledging citizenship? And shouldn't perhaps the course, I mean, that's not possible. It can't have been thought properly through, because the directive implements that primary right. And then you say, we will have the directive, but we will not have citizenship. So maybe the EFTA court could have said, well, that's not possible. So even if you have this declaration, by implication, somehow, by accepting the directive, you contracting parties have somehow accepted this individual right, at least to a certain extent. And that could be the basis. That is sort of it follow. I mean, then you don't look for a specific article in the directive, but you say it's just a necessity. If you take in a directive, you must have some kind of primary right to move as well. Instead of pretending, in my view, that it was there already back in 1990 and free movement of persons. I'm not convinced at all by that attempt to establish that it was there from the start. Supreme Court tries very hard to argue like that. It's just, sorry, it's not convincing. It wasn't there. But maybe you could say, by taking in the directive, you just had to take it. Then, by implication, you took in that right as well.
I think you don't have to take citizenship. And I think when you read the declaration, and by 2007, there was enough evidence that citizenship was being used by the Court of Justice, okay? So by 2007, there was enough evidence. What's emphasized, I think, also is the political dimension of union citizenship, the rights to vote and so on. Fair enough. And also that aspect of union citizenship has really only been developed in the last 5 years or so by the Court of Justice itself. So there was a precautionary approach to accepting citizenship, I get that. And I don't think, as I mentioned, the status is there. But wouldn't it have been wonderful if we could go back in time and say, we don't have the concept of citizenship and its political implications, but we do in the agreement have a primary right to move, an individual right for persons. So you don't need the status, but you do need a status. And it's there, in my view, in Article 1. It's there. So of course later provisions talk about workers, but it's the same in the EU treaties. But the person is there, right in the first provision of the agreement.
And that was the penultima question, because there is one here. I think it was Jonathan Tomkin, please.
From the Legal Service of the European Commission. So I'm not sure. I don't know. It's working. It's interesting because it was. I was going to ask pretty much the same question, but from the other side, which is that, of course, if we look at Article 21, it's citizenship and non-discrimination. That is that part of the treaty. And I suppose the question is that what is the added value then of the word, citizen? Because what's, and this is, I was going to say, that part of the original sin indeed is this conflation that, like, I would have thought that there is indeed free movement rights for economically inactive before the creation of citizenship. So what Article 21 does, it creates a kind of a new normative basis for a right that existed previously. But on that basis, maybe you wouldn't have needed to have the right of economically inactive free movement to be there. It could have been somewhere else. But suddenly it got relabeled as part of the essence of being a citizen. But then by creating that, then it becomes you create the problem that then if you want to take that right, you then also have to take the status with it. So what I'm wondering is that apart from the fact that that legislative technique or that treaty drafting technique has been there, is there anything deeper that the fact that one refers to the right of citizens? And there I'm thinking also of the fact of the values, because we think of citizenship as being part of the values. We think of an area of freedom, security, justice, which we're creating, where people can move. So it feeds into a kind of a bigger concept of free movement. But is it like, was that the original sin? Should it have been divided more clearly, or how should we be more mindful, or how should the court be more mindful, or the Commission when pleading its arguments on that basis? Thank you.
Thank you, Jonathan. I mean, of course, we all sit here with hindsight at the moment as to how the law has developed and with a lot more knowledge of what has happened. I do think there is something about membership of the political community that makes citizenship distinctive for member state nationals. I realize that in the Ruska Federiska case, the court is careful, the Court of Justice, it talks about being in an objectively comparable position to. It doesn't equate status. What I also think is more interesting in recent case law of the Court of Justice is the increased references to the wider system. And that special system, even like you have two special systems here, but that particular specialness is relevant, I think, to the citizens who are governed by that system. So I think there is something there about the political membership idea which is really blossoming at the moment, and it is very specific to the EU system. Since this is the last question, I'll be extra provocative and say, to me, the Ruiz-Zambrano case law, the ultimate home state case law, is arguably connected to movement. I mean, the Court of Justice keeps insisting, this isn't about the status of citizenship, this is about the intrinsic connection to movement. So, EEA friends, Ruiz-Zambrano is arguably perfectly shareable with the EEA context. And I'll go into hiding now.
And we'll give you the applause before you go into hiding.
We have one more speaker before we go into a well-deserved lunch break. And that is Cecilia Rixala. And you are professor of European law and human rights law at the University of Louvain, which I have to say is one of my favorite places in Belgium. You are Leuven. Oh, well, there you see my misunderstanding all from the beginning. But now you have the possibility to invite me to another of these favorite places. So, and it could be. So, you have worked extensively with both human rights law and EU law, dealing with both substantive and institutional questions, I would dare to say, and core principles such as democratic values, judicial independence, and And what we are going to hear more about now, which is probably the one thing you have worked most on, is the concept of mutual trust, which we have heard was the topic of your PhD and which you won several prizes for, and which is published in both French and later in English as well. And your lecture here today will follow up on that topic, but I think with a twist of EEA law maybe, which we do like to introduce on these conferences of ours. So, your lecture is entitled Mutual Trust by Design, Exploring the Variable Degrees and Foundations of Confidence through the EU-EEA Special Relationship. We will have time for questions afterwards, so I hope you have them before we take lunch. And now the floor is yours, Cecilia.
Thank you very much. Yes, I had to be honest. I don't think Louvain-la-Neuve is anyone's favorite place in the world, even if the university is amazing. But for those who already visited the city, we lost in change, because before Leuven was also the city of UC Louvain. But I won't go into details. Maybe for the lunch break, the little story about the change. And now, so it's UC Louvain in Louvain-la-Neuve, but I have the chance to be in the Brussels campus, which is, I mean, I don't know if I have Louvain-la-Neuve colleagues here, but anyway, let's stop with undiplomatic wordings. So their esteemed colleagues, their president, their judges, advocate generals, I'm deeply honored to have been invited, such as my colleagues, to reflect, so as it was said, on the principle of mutual trust today, a principle that specialists of EU law have long been familiar with and fighting with, I will dare to say. And as you said, I will try to discuss this principle also in relation with the external relations of the EU, and in particular, the relation with the European Economic Area. But I will immediately raise a caveat, if I can. I'm not a specialist about external relations, nor EEA law, so I learned a lot, and I will nevertheless do my very best, of course, to navigate in the complex landscape. Complex, but not less important, indeed, as it was already said several times this morning. But allow me first to warmly thank the organizer, the EFTA Court, Olafur, to kindly extending this invitation to me. But I must confess that when I first began to examine this question, I had a little sense of vertigo. You know, so as it was said, I worked on mutual trust in a cross-cutting manner in all the fields it is applicable in EU law, and already it was a huge challenge. And at that time, I decided to protect myself a little bit and say, okay, I will only focus on the relationships between the member states. But I had to note that mutual trust was also used as a term, explicitly mutual trust, confidence, in relation to third states. But I was like, at some point, you have, when you do a PhD, you have also to focus on a topic and to it was my PhD director that told me also, you have to limit yourself, otherwise you will never finish. So I decided to rely upon that to protect myself and to focus on the relations between the member states. But so now I will try to extend a bit this reflection to the relations with third states and the EEA states in particular. But I will first introduce a little bit the findings of on the definition on mutual trust and how it has been, according to me, developed in the framework of the EU. So first, we have to observe that mutual trust is used in many different fields of EU law within the relationships of the member states, and in different manners. And even sometimes in the same field, you can see the use of mutual trust in very different manners. And I have one example that struck me lately in relation to the criminal cooperation, judicial criminal cooperation. If you compare, for instance, the European Arrest Warrant Framework Decision that is very well known, and the more recent directive on the European Investigation Order, two cooperation mechanisms in criminal judicial law that both implement mutual trust. However, if you compare the exceptions to mutual trust in those both instruments of the same field, they are very different. In the European Investigation Order, you have a general exception on human rights, while you don't have such an exception, general exception, in the field of the European arrest warrants. Even more striking, I would say, I was quite surprised when I saw that in the case law of the Court of Justice, that the definition of the concept of national judicial authority, an autonomous concept in EU law, according to the court, that enables an authority to issue a European arrest warrant or to issue a European investigation order, these authorities do not have the same definition into EU law, while it is the same word. National Judicial Authority, same field also. So you see, it is quite a complex, complex landscape in which the principle of mutual trust exists. And the Court of Justice has also several times said that mutual trust was a specific characteristics of the relations between the member states, a principle of fundamental importance, if I quote Opinion 213. And so I also had the excuse to focus on the relations between the member states. However, as the International Court of Justice already stated in 1974 in the nuclear test case, any form of international cooperation between states necessarily presupposes a certain degree of trust in their relations. And this will, I guess, also ring a bell with the specialists in the room in EU external relations and EEA relations. There must be some trust within these relations. At first sight, the concept of mutual trust also appears as a positive and simpler concept in this framework. There is trust between states, and so they decide to collaborate in the international relations. In the EU, it was first introduced as such concept, such easy concept, actually in the early 70s in a very pragmatic way in relation with the mutual recognition of diplomas of certain regulated professions, such as midwifery. So at that time, the EU adopted several directives imposing automatic mutual recognition of diplomas, so not the general framework, which is not automatic, but very automatic and unconditional mutual recognition of diplomas, in certain regulated profession. And within this directive, you see the notion of trust, in particular in the travaux préparatoires, in relation to national certificates attesting, for instance, the fulfillment of the requirement of good character and good repute, or the physical and mental health of professionals. So there was the idea that national authorities should simply trust if one citizen of the EU comes with such certificates. But since then, as I already underlined, the scope of this principle has considerably evolved. Now it is invoked in almost all the fields of EU integration, be it explicitly or implicitly. If you have a definition of mutual trust, actually you see it everywhere. And according to me, it now became a genuine structural principle of EU law, inasmuch it governs legal relations between the member states, a principle that has an importance comparable to those of the principle of direct effect and primacy. However, I think it is also important to underline that mutual trust, I would say, is not recognized as having an autonomous scope, an autonomous effect. In practice, mutual trust is implemented by other rules of EU law, whether primary law, for instance, freedom of movements, or union citizenship, as illustrated in the recent Maltese visa case. Primarily law, but also, and maybe most importantly, secondary legislation, such as the framework decision on the European arrest warrant that I already mentioned, the European investigative order, the Dublin regulation, many regulations in the field of mutual recognition of judgments, or even, Professor Tuidimas said today, the directive on firearms. You see, mutual trust is almost everywhere. And usually, I observed that the court invoked the principle of mutual trust and definited the legal consequences to draw from this principle on the basis of this, the substantive rule of EU law that the court applies. So even if it is a judge-made principle, because mutual trust actually is not written in the treaty, I didn't say it already, but it's not written yet, I would say maybe in the treaties. So even if it is a judge-made principle, the Court of Justice determines the exact consequences of this principle in relation to the substantive rule that is applicable in the case at hand. But I, however, tried to define this principle, and I had to do it in a very abstract manner because it has many, many different I would say, way of implementation in this, this landscape. And I decided I proposed, I would say, to define mutual trust on the basis of the presumptive mechanism, the presumption, really looking back to general theory of law, actually, and how presumption works. And simply put, I would say that the principle of mutual trust requires member states in their horizontal relations to presume the compatibility of rules, practices, or legal situations emanating from the legal order of their peers. So I took all these as, I refer to this as legal solutions. So member states can be required to presume the compatibility of legal solution of other member states within their own legal order, including, and maybe most importantly, as regards compliance with fundamental rights. This presumption I also observed in my PhD, which dates back from the 2020, so it has evolved since then, but I also observed that this presumption did not bind the EU nor EU institutions. The Commission can, of course, intend infringement actions against member states that would not comply with EU law, and the Commission is neither the courts required to presume the compliance with EU law by the member states. However, there is this more recent judgment, Spet Pro from the General Court, where their mutual trust was applied in the field of competition law, and where the General Court said that there is mutual trust obligation also between the national authority and the Commission within this framework. So you see, even that is no longer a general consequence of the principle of mutual trust, but I would say that as a principle, as a matter of principle, of course, EU institutions are not obliged to trust the compliance with the EU law by the member states. Moreover, member states can also intend, and we know it, infringement actions against their peers. So there is not an obligation to trust for the member states the compliance, to absolutely trust the compliance with EU law by the other member states as they can, and they are even sometimes invited to intend infringement actions against their peers. So I would say this duty only applies within their horizontal direct relationships, but they can use the institutional framework to put it into question, and it is also how actually it is the autonomy of the EU system is preserved, and it is also actually on the basis of mutual trust that the court, very long time ago, said that the principle of retortion, as we know in public international law, does not apply within the relationships of the member states. So a principle that imposes a presumption of compliance, and this presumption can be declined in two different ways, depending again on the rule that is at stake. Either mutual trust will impose a concrete presumption tied in a common harmonization standard, so mutual trust are requested to trust, member states are requested to trust the correct application of a common standard by their peers, or mutual trust will impose an abstract presumption of equivalence in the administration of justice. So more broadly understood, this is the case, for instance, with criminal law cooperation. There is some harmonization, but in the most part, national criminal law systems are not harmonized, they are different, but there is a mutual trust obligation with regard to the general capacity of national legal orders to render justice. A presumption, if you go back to the theory on presumptions and presumption mechanisms, a presumption normally has a foundation and also can be limited. And this is, of course, the case also of mutual trust. So I will not learn you anything by saying that the principle of mutual trust is justified within the EU, at least from, I would say, 20 years or so, or a bit longer, on the fact that all the member states are supposed to, I'm adding that, share the values set out in Article 2 of the TEU, namely the rule of law, democracy, and human rights. The Court of Justice qualified this Article 2 statement as being a premise, and this premise justifies the principle of mutual trust. I was also a bit critique from my academic seat on this reasoning, because how do you want to find a presumption on another presumption? I mean, it is a premise, but can we really qualify the fact that the member states share all this value as being a premise? I will stop here and I will let you reflect on this question in the current times. Because indeed, this premise is experiences very difficult times now and since the past decades. And the Court of Justice has had in fact not other choices than to define limitation to the principle of mutual trust, because of this foundation getting more and more put into question. Many exceptions were developed, notably in the view of protecting human rights or the rule of law, judicial independence, for instance. And unfortunately, I cannot go into detail in this case law now because it's a very, very sophisticated and rich body of case law. But I will simply underline, and I already said it, this case law demonstrates the multiform, the protein nature of the principle of mutual trust, because the exceptions of mutual trust are not at all the same from one field to another, and even, as I said, from one instrument to another in the same fields. But I would like also to say that, in a way, I understand the Court of Justice when it developed this case law, because the consequences of mistrust, of distrust, so of setting aside mutual trust, in one field or in one instrument compared to another are not the same at all. If a state set aside the presumption of compliance in the field when applying the Dublin system, for instance, and so not transferring asylum seeker to another state who would be responsible according to the Dublin regulation, what will happen? If you read the Dublin regulation, it will be another state that will be responsible. And there is even a last safety net that said that if no member state is competent or is responsible according to the Dublin regulation to assess the asylum claim, then it will be the states where the asylum seeker presents its demand. So there is also this aspect of the Dublin system that we often forget, that it was also adopted in order to protect and to fight against the asylum seekers in orbit without having a place where to ask asylum. But what happens if a state, a national authority, mistrusts another national authority in the framework of a European arrest warrant? There is no obligation for that state, and sometimes not even the possibility with regard to national law, to sue or to prosecute or to have the sentence executed in the national legal order. So you have a genuine risk of impunity that was raised already in many conclusions of advocate generals in the field. And so, of course, the risk that the distrust implies into these different areas is very different. That's just an example. And so it can also explain, of course, why we have different types of exception schemes. So that was a bit where I started when thinking about the principle now of mutual trust with third states. So I also want to recall, and I did that at least a bit in my book, that actually the principle of mutual trust was already used in the 90s with regard to third states a lot in many judgments by the Court of Justice with regarding to custom unions and the trust that national authorities should actually show to themselves within this framework. In particular, within the framework of cooperation agreement establishing preferential arrangement with third states. According to the court, indeed, this type of administrative cooperation rests on a division of tasks between the authorities of the member states of imports and those of the member states of exports. Because of this trust, European Imports Authority must rely on the factual findings of the authorities of the exporting states, third states, since those authorities are in the best position to verify the product as such. Actually, it is really the same reasoning behind mutual trust within the member states. We speak, of course, about another object, but the reasoning is very similar. However, you know it, and we already said it today, more recently, the Court of Justice has also underlined that mutual trust is special for the relationships between the member states. I will here refer to the opinion 117 of the court, where the court said that the union presumption that all member states comply with EU law and provide equivalent and effective protection of fundamental rights rests on the fundamental principles that they share common values. Such a presumption cannot, in principle, be extended to third countries. That being said, specialists in EU external relations, I suppose, will immediately recognize from what I said that mutual trust is also used and translated into a part, at least, of EU external relations. And there is a certain degree of trust that is materialized within these agreements. So I believe, and the Court of Justice actually said it almost explicitly, that this close mutual trust principle for the member states should actually be nuanced, and some mutual trust can be recognized also in relation to third states. And this point is actually also confirmed by the draft accession instruments relating to the EU accession to the ECHR. You know that in Opinion 213, mutual trust was one of the obstacles identified by the Court of Justice for the accession. And within these new draft agreements, we see that it is stipulated that mutual trust can also be relevant to non-EU member states in the context of bilateral agreements concluded with the EU. In the same vein, President Koen-Leenaerts and in his academic capacity, and José Guitterier-Fons recently acknowledged in an article of 2024 that a third country may gain that trust if it establishes a special relationship with the EU and is equally committed to upholding the values on which the EU is founded. So it seems to me very interesting in this regard to first analyze briefly the case law of the Court of Justice in relation to the United Kingdom, and in particular since Brexit, and then I will move on to the case law which is very much linked to in relation to the EEA. So the case law since Brexit. So first there were several cases that were rendered, judgments that were rendered in this in-between period before the conclusion of the trade and cooperation agreement. I will not go into detail here, but they are very interesting. So if you are interested in that, I really invite you to read the cases, notably RO, where very briefly the Court of Justice said that despite the fact that the United Kingdom will very soon leave probably the EU, so at that time, mutual trust should be at that time applied business as usual without having in mind the possible consequences of the fact that the United Kingdom will leave the EU. But since then, we see a very much different line of case law. So the first important case was already mentioned, the Alcaster case, Alcaster 1, because now we have an Alcaster 2 case, where the Court of Justice had to respond on a question in relation to the execution of a surrender to the United Kingdom. So the mechanism that replaces the European arrest warrant in the framework of the UK-EU relationships. And here, the Court of Justice, very clearly stated that the duty of mutual trust, which implies a presumption of respect of fundamental rights, in particular in this framework, for national authorities, was not applicable to the UK, and that a full control of respect of fundamental rights should be from now on, conducted by the national authorities that surrender people to the UK in case of risk for fundamental rights. So it founded this finding on three main elements. First, that because this trade and cooperation agreement, according to the court, does not establish a truly special relationship between the EU and the UK. In particular, the court noted the UK is not part to the European area without internal borders, the construction of which is facilitated inter alia by the principle of mutual trust. Moreover, although cooperation between the UK and the member states is based on a long-standing respect for the protection of fundamental rights and freedom, the cooperation agreement is not presented as being founded on the preservation of mutual trust, nor the values of Article 2. And thirdly, and maybe most importantly, there are substantial differences between the provision of the trade cooperation agreement and the European arrest warrant. So as a result, national authorities are required to fully control, in the same manner they would cooperate with another third state, the respect of fundamental rights before executing a surrender. And this is, of course, also interesting in light of the ECHR obligations, because we know that a state can be held responsible when the violation of the ECHR by another state. It's a very old line of case law, and that's also why it was problematic regarding mutual trust. But here, full control according to the court, and the court also confirmed that in the very recent Alcaster 2 case, where the Court of Justice said that the full control, in particular of Article 49 of the Charter and the principle of legality and proportionality of criminal offences should be controlled before authorizing the surrender to the UK. So let us now move to the relations between the EU and the EEA. So from the perspective of EU law, the court has also recently, and in particular in this Alcaster case, underlined the special relationship that binds the EU and EEA states. And in this respect, we should of course note that Norway and Iceland are associated with also the European Criminal Cooperation Scheme with the surrender procedure agreement that entered into force in 2019. And in the seminal judgment that was already mentioned, Ruskia Federica, the Grand Chamber of the Court of Justice held that this agreement should be interpreted in line with the European framework decision on the European arrest warrants and the surrender procedure between the member states. So more specifically, the question was whether the agreements concluded with Iceland and Norway meant that in that case, an Icelandic citizen arrested in one member state on the basis of an international arrest warrant that was issued by Russia, if that member state should first shield this individual from extradition to request if Iceland would like to request his surrender instead. Actually, this question was already settled with regard to member states' relationship in the Petrine judgment and the following case law. And in this Ruskia Federica judgment, the Court of Justice said that since Iceland enjoys, and here I'm quoting, a special relationship with the European Union, going beyond economic and commercial cooperation, as it is a party to the agreement on the European Economic Area, participates in the common European asylum system, implements and applies the Schengen acquis, and has concluded with the European Union the agreement on the surrender proceeding between member states of the EU and Iceland and Norway, the court held that in the field of cooperation, a member state that receives a request for surrender from a third state concerning an individual from Iceland or Norway should first refer to Iceland or Norway to ask if they would like to protect this citizen from extradition. In other words, the court just required member states to recognize, to apply this preferential regime that is normally reserved to EU citizens because of this special relationship. This judgment was also confirmed lately in a GR judgment, where the case concerned the execution in Ireland of an arrest warrant issued by Lithuania based on a custodial sentence imposed by a Norwegian court. The court reiterated that Norway enjoys a special relationship with the EU, and therefore Ireland should execute that European arrest warrant in order to enable the execution in Lithuania of the Norwegian sentence. Of course, there is an apparent paradox. Article 2 of the TEU, this premise is not as such referred to with the Norway nor Iceland, and the Charter of Fundamental Rights, which is also presented as a genuine cement of mutual trust, is not as such, at least, part of the deal, I would say. So how can we justify that paradox? I try to find possible answer to the questions. So first, the preamble of the surrender agreements affirms, and this may be, of course, game-changing, affirms that the parties, affirms the mutual confidence between the parties in the structure and functioning of the legal system, as well in their ability to guarantee the right to a fair trial. The provisions of that agreement are also very similar to those that we find in the Framework Decision 2002-584. And something even, I would say, more convincing, but that is also paradoxical, even among the member states, we do not have exactly the same, we are not subject exactly to the same acquis. Let's think about the minimum harmonization directives in criminal law that were adopted specifically to support mutual trust as being needed, actually. Okay, we share the same values, but we know that criminal systems, national criminal system can be very different, and so we need some harmonization in order to support this more abstract presumption of equivalency in terms of justice. But Denmark is not subjected to these directives, and still it benefits from mutual trust. Finally, I also think that the readiness of the Court of Justice to extend mutual trust to the EEA can also be explained by the close and constructive relationship it has with the EFTA courts. And the recent case law demonstrates this work in French, we would say, in bonne intelligence of the two courts. So in a judgment of 7 May last 2025, so very recent in the TC, the EFTA court relied on the principle of homogeneity to justify that general principles of EEA law, which include fundamental rights, should be interpreted in light with the EU Charter. According to the court, the principle of homogeneity leads to a presumption that a provision framed in the same way in the EEA agreement and EU law are to be construed in the same way. Nevertheless, and this, of course, makes a link with the previous presentation, it added that differences in scope and purpose, however, may, under specific circumstances, constitute a compelling ground for divergent interpretation between EEA and EU law. But it doesn't seem to be the case within the realm of the Charter, which can also justify mutual trust. The EFTA Court has also recognized the existence of this special relationship between the EEA and the EU in the A and B case of December 2024. On that occasion, your court emphasized that in the context of a possible relocation of a child from Norway to Denmark, Norway should trust that decision regarding the custody regarding the custody will be properly enforced and respected by the Danish authorities. So this is also, of course, a manifestation of mutual trust. And also, I would say that an important aspect is the national level, where we also see the principle of homogeneity in action, at least in some cases. For example, in Norway, the Supreme Court, which is not formally bound by the case law of the Court of Justice in relation to the European arrest warrant, applied the exact same methodology with regard to a surrender request that was done by the Polish authorities. So for those who are familiar with this case of the Court of Justice, the LM case with the two-step approach with regard to the risk in terms of judicial independence, the Norwegian Supreme Court applied it, while it was not bound to. And interestingly, there was even a case brought in front of the European Court of Human Rights in this framework, but it has been dismissed because we were waiting about the judgment of the European Court of Human Rights, and maybe if the court would have also been lenient in a way as it is with regard to the specific construction of the EU in the framework of the relationship with Norway, but we still have to wait maybe to have a response to that question. And this special relationship also shows itself in civil judicial cooperation. If we look at the Lugano Convention, for instance, it extends the EU regime on mutual recognition of judgment in civil and commercial matters established by the Brussels I bis regulation to all EFTA states except Liechtenstein and to Denmark. By comparison, the European Commission gave a negative opinion on the request of the UK to join this convention. The Commission highlighted the high level of mutual trust among the contracting parties, which it said reflects a high degree of economic interaction based on the four freedoms. I will also just underline that, of course, there is also a participation in the Common European Asylum System, which is also, at least partly, founded on mutual trust. So to conclude, I wanted to borrow actually the word that I found very enlightening of Advocate General Spooner in the Alcaster 1 case, where he spoke about a sliding scale of mutual trust. He explained that there are different forms and permutation of mutual trust, and I cannot agree more, as I already said. It is not a binary concept. There are different degrees, and we can see this not only with relation to the third state, but that was also the message of my presentation, even within the EU, and there are very different degrees. What I would maybe say, after having the occasion of analyzing these different manifestations of trust, is that for the moment, at least I would say that mutual trust can be presumed between the member states, while it should be gained in relation to third states. But in the current context, I'm not sure if we will be able to continue to draw this conclusion, but I thank you for your attention.
Now, thank you to you too, Cecilia. I think you've, in a very short time, has been able to show us how, on the one hand, how complicated this issue is, and on the other hand, how extremely practical it is. And even though it can mean, mutual trust can mean many things and have many functions, like from a very practical perspective and from the perspective of a judge, what it sort of allows me to do in very simple form is to trust someone else. And what that allows me to do again is really, based on that trust, not take a stand on the substance. So you defer to someone else based on this trust. And this trust may of course be strong, and or it may be weak, which again sort of influences where you ended up, or might influence where you ended up, that there is a sliding scale of mutual trust. And I would say that no trust is absolute. So you can't, at least as a judge, you cannot just hold your hands up and defer as much as you want to anyone. So, and there we are with the exceptions that you didn't really want to enter into, or you didn't because the exceptions are so many and they are different. But what you do as a judge is you sort of, when these cases arise, it's sort of, well, there is a presumption, there is a trust, and then you ask yourself, in some sense, how can this be rebutted? And what kind of criteria can then rebut a presumption? And is it possible to say something more generally about that, what it should be?
Yes, of course. So it was just not a choice also, but I would I needed like 400 pages or 500 pages, I don't remember, in my book to discuss this. But yes, indeed, it's very complicated. And actually, as an academic, because I know it's much more complicated when, I can imagine when you sit in a court, but I proposed a new method of application of mutual trust in my book based on a risk assessment. And so I, of course, know if one of you go to consult this method, it's with a table, with situation A, B, problem. And I am, of course, also, I realize that never a judge will use that method, and it's much easier to develop such a method as an academic than to apply it in practice. But basically, I relied upon the idea of a risk assessment that would also be based on the consequences of the disapplication of mutual trust. I also relied a lot on proceduralization. So indeed, I think that trust materializes the idea of trusting the substance of the judgment. But for me, it's very important to see who is and which are the qualities of the authority that delivered that judgment. For me, that is a very important aspect, the proceduralization of trust. And while if there is a problem in the quality of the court or the national authority that would deliver the judgment, then there is kind of a rebuttal already. And also what I developed is something based on non-discrimination law, which I found very interesting, with this rebuttal, I mean this burden of the proof that is organized in different way by the non-discrimination directives. So the idea is that when someone complains from being the victim of a discrimination, this person would only be required to bring prima facie evidence that there is a discrimination, and then it is for I would say, the strong party, the employer, to rebut the presumption of discrimination based on this prima facie evidence. And I was trying to find solution very modestly, and I was like, but this is a good idea. Maybe we could say that when there are systemic deficiencies in one state, I wouldn't say, I think it would be very dangerous to say that you don't execute any European arrest warrants that were issued in Poland because of the systemic deficiencies with regard to judicial independence. No, but then it is to the Polish authority that to prove that in that case at hand, this systemic deficiency will not have individual consequences. So not a rebuttal, but in French, sorry, I wrote that piece in French, so aménagement de la charge de la preuve, where you say that when there is a systemic deficiency, it is to the other states. The states requiring trust to prove. And here also it's complicated, because when it is a European arrest warrant, the state issues, a national authority issues and asks for trust. When you think about the Dublin system, no state asks for trust. The other states want to say, I want to trust you, so I will send you back the asylum seekers. So I would say that, to be really specific, it is the state that benefits from trust, that requires the trust. So it is not all the time the state where the person will be surrendered, for instance, but the state that wants to rely on trust has to rebut the fact that there will be no individual risk if there are systemic deficiencies. That was my 5 cents and an idea that I developed in my book.
Thank you. So I'll refrain from, even though it's very tempting, but we need some questions from the floor as well. So yes, front row, please.
Thank you. Arne Finn Boelsen, Vice President of the European Court of Human Rights. Thank you very much for a very inspiring intervention. I have 3 points. First of all, you mentioned a very interesting Polish case that somehow found its way to our court. And just to wrap up that case was not decided simply because it turned out that the applicant would not be sent out of Norway anyway, at least not for now. And you know, we have certain criteria, and therefore, so ultimately we might have to struggle with these issues. Second, more of a reflection. I mean, the discussion of mutual trust, as seen from our perspective, also have a very important connection with what is more and more the daily basis of our work, namely subsidiarity and shared responsibility. Namely the fact that in implementing the European Convention on Human Rights, we more and more try to push the application of the Convention over to the domestic authorities and notably the domestic courts. And that provides us with a very flexible tool based exactly on this sliding approach that some member states, they can prove themselves to be trustworthy because they do the job, and they demonstrate that they do that, notably, for example, the way that the apex courts are reasoning their judgments to explain and to show how they apply the convention in a way that we would do exactly the same. That would allow us to take a step back and to say, okay, we trust that you did the job. And this is something that will develop over time. It cannot be done overnight. I mean, trust is something, as you also rightly highlighted, something you have to build. But this also, of course, obviously, on the other side of the road, you have some member states that are not trustworthy in this sense, which would then oblige us, even as an international court, to go more deeply into the assessment that was done domestically. This is part of, this allows us also to uphold the idea we have a common set of values, a common set of rules and obligations under the convention. But nevertheless, the way we apply our international control would somehow not be the same vis-à-vis all member states, simply because the convention is not implemented in a similar manner throughout Europe. That was at least part of a reflection. My third point is rather a small question when you discuss the relationship between the European Union members and the non-members, but now notably Iceland, Liechtenstein and Norway. And you mentioned some elements possibly building, let's say, building a basis for mutual trust vis-à-vis these EEA member states. You mentioned also in that respect the Charter of Fundamental Rights within the EU. I think we also need to mention that all these 3 member states are full-fledged members also of the European Convention of Human Rights. And in that respect, all 3 of them would probably belong to the member states that already have proved themselves trustworthy when it comes to implementing the convention. And to the extent that that convention somehow provides a similar basis for mutual trust as the Charter, I think it needs to be taken into account. Thank you.
Just briefly, many thanks. And of course, I think that everything you said was very important. And I will just reflect to the last point and also, I mean, more globally about the importance of the ECHR. I think one of the big risks also of these presumptions, because I will speak with the plural, because there is a mutual trust presumption, but there is also the Bosphorus presumption. And then if you think, I wrote something about this, many applications of several presumptions, where is the control? The Solange presumption at national level. So I think that, in fact, I was reflecting on what you were saying, but the protection with regard to Norway and Iceland would be better guaranteed because, if I'm not mistaken, for the moment there is no Bosphorus presumption that is recognized in that fact. So actually, trust would be founded on a more strong foundation and possibility of control, because what happens, I mean, the case law, your case law is very, very also sophisticated and interesting. And so I won't be fully representative here about all these different cases. But what happens when you have mutual trust and then you have the application of the Bosphorus presumption? Then there is no control. If you have mutual trust with regard to Iceland and Norway, and then you can go to the court and you have a full control with regard, of course, this subsidiarity, the trust within the state, but not the Bosphorus presumption. I think the control can even be, I mean, the mutual trust can even be more justified, which is a bit counterintuitive, but.
There is one question on the front row here, and then it's one on the second row, and then it's one in the back. So I think we'll collect some, and then you can answer afterwards. And if there are any more questions, please give me a sign, and then I will.
Yes, thank you, Cecilia, for an excellent presentation. My name is Gunnar Þór Pétursson from Reykjavik University. I learned this morning that President Trump has said that special relationship is not a term to be used any longer, defining the relationship between the US and the UK, but this is a unique relationship. So for him, in the words of Johnny Logan, not enough words. But I was thinking actually about the different use of terms. And as you explained, of course, mutual trust is a value-anchored constitutional principle of EU law, judicially construed with the support, of course, of both Professor Lennartz and President Lennartz. But we see in the Ruska Federacija case the use of this term special relationship, but there is no explicit mentioning of mutual trust. Then we see also the use of the term mutual confidence in subsequent case law, also used by the EFTA court. Are we on the sliding scale? Do this term really matter? What is your view on that? Is it possible to go all the way to a similar mutual trust constitutionally value-based principle in EEA law?
Thank you. I think we'll collect one more from the right-hand side, and then we will take the two on this side again.
Yeah, Raphael Meyer from the judge at the General Court, so across the street. My question relates a little bit to that, because we talk about mutual trust in very different area between, I mean, the two sides of the two pillars of the EEA agreement. As you alluded to, in the criminal area or in the arrest warrant, we don't have the EEA agreement, if I'm not mistaken. So we don't have the structures, we don't have the court, we don't have the EFTA Surveillance Authority. So can we really have the same type of mutual trust between member states and across the two pillars in an area which is not covered by the EEA agreement? Thank you.
Thank you very much. So actually, the two questions are a bit related about this proteiform and multiform principle of mutual trust. So first, with regard to the terms and words, I know that some authors and some stakeholders attach some importance on that. Me, to be very honest, also, so my PhD was written a long time ago now, and it was published in 2020, but you will see in the introduction that I said that in French, and then translated, confiance réciproque and confiance mutuelle, je les prends comme synonymes. Because if you compare mutual confidence and mutual trust, if I'm not mistaken, but it would be maybe good to have a very strong analysis and of all the cases, what I did before 2020, but they are sometimes used interchangeably within the EU. If I'm not mistaken, I should verify this, but I should verify. But I think that in the European arrest warrant, it's referred to mutual confidence, confiance réciproque. And also, if you compare the words in French and in English, so on one hand, we change confidence to trust, and the other, it's confiance, réciproque, and mutuelle, while réciproque and mutuelle are really synonymous in French. So I decided it's maybe a mistake not to attach too much importance to this formal question. And also, I felt that there was nothing, so as we all understood, mutual trust is so different, the exact consequences, the degree, and even sometimes the functioning differs from one instrument to another. So if in addition we try to find a way also of differentiating these two terms, then I think we won't be able then to draw a general definition, what I try to do, and a general definition that is very abstract. It is this presumptive mechanism, and with the risk it entails. Actually, the exercise was also useful, I think, to really emphasize the risk that it entails. But for me, there are different degrees, different types of application of mutual trust and confidence, and there are no, I think, I would say, very coherent and systematic change in the wording, neither in the political documents, maybe less even, neither in the preamble of the acts, the legislative acts, nor in the case law of the Court of Justice. But that's my opinion on that. And so, for the second question, I think it's indeed a very important question that also shows how this trust is very different and function with very different foundations, sometimes with the control of a court, sometimes without the realm of a cooperation mechanism that is indeed related to the EEA, but is not formally within this institutional framework. And there, indeed, I think that it is a matter of degrees. If we just take mutual trust as defined as being actually very pragmatically a mechanism of international relations that institutionalize a form of presumption, then of course there is mutual trust also, even despite, I would say, the absence of the court in that framework. The question is, what are the foundations? And here, if I may make a link with the first thing I said, maybe the foundations are even stronger, big thanks to the European Court of Human Rights and the absence of the Bosphorus presumption. But what will happen in case of accession? This is also, of course, a very important question, and we don't have the time to speak about everything.
I have one more question on the right here, and if there is another one, if not, then we will let that be the last one, and we'll go to lunch afterwards.
Hello, I'm Kieran Burke from the EFTA Surveillance Authority. Thank you for the excellent presentation. I have a question that goes to, systemic integration of law, as the ILC would call it. I'm very grateful that you mentioned the nuclear tests case, because I think we have sometimes the tendency to live in our own little European bubble. But with that being said, I'm just wondering about the words mutual trust and where they came from. Because obviously we as you're probably aware, these are words that do come up in public international law from time to time, and they've been used, for example, recently in the Venezuela-Guyana case. And essentially here my question relates to the development of principles by the Court of Justice, because the Court of Justice has come under fire from public international lawyers for developing principles of public law rather than principles of private law, and that this has to some extent impeded a principle like good faith from being fully exercised within the context of the European legal order. Now, my question really is whether the advent or the ingress of this principle into the European legal order has the capacity to affect relations between states beyond the context of EU law. Insofar as I noticed that the agreement that was finally reached between Italy and Germany in relation to the state immunity dispute explicitly mentions the relations between the states being based upon the principle of mutual trust, which suggests that their relations as a matter of public international law in state immunity, which has nothing to do with EU law, are different to their relations in other contexts. So I'm just wondering if you could reflect on this, please.
Thank you. Are you? Yeah. Thank you very much. So, it's indeed a very interesting question, and also major caveat. I'm not a specialist about public international law at all, but I think that there are direct consequences. And I will also now go on a field that I am really ignorant of, the field, the Achmea case and these investment tribunals and between states that are concluded, if I'm not mistaken, outside the scope of EU law at all, and that are now member states are prevented to do that. And even, if I'm not mistaken, Norway terminated all this BITS agreement also because of mutual trust and in order not to avoid national judicial authorities who are trustworthy. So I think definitely there is a consequence. And also there is a consequence with relation to the European Court of Human Rights. We see it where the Court of Human Rights is, I don't know if it is obliged to, but at least in a way, take some consequences of this special relationship within the EU, or at least framed by mutual trust. So I think there are consequences, of course, also without outside the exact realm of EU law. But I would say the EU integration is now so deep. Could we really consider that that the consequences are only limited to the relations that are concluded within the scope of EU law? I don't think so, and this is also the case for mutual trust.
I think that was a very good concluding point, and we certainly owe you a good round of applause. So, lunch will be served on the other side, and I propose we take lunch for an hour. So we'll return at 14:30. Thank you.
Good afternoon, Excellencies, ladies and gentlemen, dear colleagues. Good afternoon. I hope you have enjoyed our small lunch. Small in the sense we gave you only 1 hour to eat, so sorry for that. I am Bernd Hammermann, the judge nominated in respect of Liechtenstein, and it's my great pleasure to moderate the afternoon session of our conference today. This afternoon session will be in 2 parts. We will have 2 presentations by Professor Dorota Lecekiewicz and Dr. George Bauer, each followed by Q&A sessions. Afterwards, we will hear the concluding address from our former ad hoc colleague, Professor Ole Mestad. As you see out of the program, there is no Q&As foreseen after Ole Mestad, but I think if we really are pressing, and if you still have time, perhaps we could get rid of certain questions to him. Allow me to begin by introducing Dorota Lecekiewicz. Dorota is Associate Professor of Law at the University of Oxford and Official Fellow in Law of St. Peter's College. Dorota holds a Doctor of Philosophy from Oxford and Masters from Oxford and Wrocław. Dorota's work has been published many, many times. Her research focuses on judicial reasoning, comparative tort law, and EU constitutional and private law. Dorota has written that she is particularly interested in how law develops through education and how particular values are promoted in arguable, quite formal legal argumentations. With that in mind, Dorota is thus perfectly placed to address us on interpreting or reasoning with law, on 2 conceptions of judicial authority in EU law. Dorota, please.
Thank you for this very kind introduction, and I hope you can hear me well. I was told that I have to adjust the microphones and speak to them, so everything is projected properly. So let me start by thanking the court for inviting me today. It's really an honor and a privilege to be able to speak on a topic that I have been researching for many, many, many years. I am fascinated by judicial reasoning, and I am an outsider looking in or looking at. And so please bear that in mind when I speak. I am an observer trying to capture certain reality, and I hope what I'm going to say is not too controversial. So let me start. So we can identify, I think, 2 perspectives on judicial authority, and the specific focus on my presentation is authority to make law. So I am really fascinated by law made by judges, judicial law. In particular, where law is made not, sometimes explicitly, sometimes implicitly, but we can actually observe a change. So it's very difficult to deny that the law that was before a particular judgment is the same as the law that followed a judgment. But we know that when that fact is being conceptualized, it is not always acknowledged that this is what actually happens. And so the Court of Justice of the European Union is trying to convince us that it is telling us what the law has always been. So the judgment, yes, defines, clarifies, but it's not like the judgment itself is introducing a change. It's just telling us what the law has always been. But, then we look to the EEA agreement and we have a completely different perspective, because suddenly we are told that law develops through adjudication. So that assumes that it's the judgment that institutes the change. And these 2 perspectives coexist against each other. So, one of the big questions is that if this is what happens, if we have to agree that the law after the judgment is different from the law before the judgment, does it mean that we are observing political activity on the part of the court? And even that assessment or that characterization is open to debate. We have many scholars. I gave you the example of Alex Stone Sweet, but we can find very similar statements from Joseph Weiler, Karen Alter, and other scholars really telling us that what the court has done is that the court has involved itself in policy making. The court revised the treaties. Yes, the treaties are different because of the statements made by the court. This is trivial, one could argue. But then we read Koen Lenaerts, who is president of the Court of Justice of the EU, and we are told that the only thing that the court has done is what the treaty required the court to do. So how can these two realities be true at the same time? Yeah, what's going on here? Who is right? Who is giving us a more accurate version of the state of affairs? So judicial lawmaking is a social fact. What that means is that if you ask a legal sociologist, they will always tell you that judges make law. But in the EU, in EU law, we cannot pin down a single provision in the treaty that says the Court of Justice of the EU can make law. So we are trying to find different terms to describe that reality. It's a de facto judicial authority. It's not a de jure judicial authority. But what's really at stake is the fact that the particular doctrines don't really have grounding in the treaty. They can be inferred, deduced, somehow argued to arise from the treaty, but they are not explicitly stated. And there are many fundamental doctrines that have that characterization, right, that have that character. Obviously, we can mention just the fundamental ones, direct effect, state liability, fundamental rights, conform interpretation, like in the EFTA court has introduced the principle of state liability, beautifully acknowledging in the judgment. I really like that paragraph in the judgment where it says it's not mentioned in the treaty. This honesty in acknowledging that the court is doing something which is not actually mentioned in the treaty. I really love the transparency of that statement. I'm not saying it's illegitimate. I'm just saying it's not mentioned in the treaty, and the EFTA court admitted that. So why there is this unease about saying that the EU court, the EFTA court makes law, introduces change, institutes change? And I think part of that is this, the fact that it's a little bit inconvenient to say that courts, any court, including national courts, make law. We still operate in the tradition where there is some suspicion about judges possessing so much power, if that's how you want to characterize it. But also in the context of supranational law, we have an additional problem, because we don't really know where the power to make law comes from. And it is particularly the case because even this implicit empowerment that can be derived from the treaty or from the EEA agreement, from the preliminary ruling procedure, from the power to give advisory opinions, even that, it's an international treaty. It's not a state constitution. It's not a document that has democratic legitimacy. So how come that we can empower, we judges, I'm not a judge, but I'm trying to put this hat on. How come that a judge can empower itself to make law on the basis of a document which is just an international agreement? So what avenues of authorization do we know? I'm a comparative lawyer, so I can look across jurisdictions. And I think, very roughly, we can identify the explicit avenue and the implicit one. The explicit one, I would say that English law actually is a legal system where the power to make law in the hands of the judges is explicit, even though we don't have a constitutional document in the UK. That's because it's a long-standing constitutional tradition. There is the doctrine of stare decisis, and so on and so on. So you can even go deeper than that. The principle of formal justice, treating like cases as alike, is so ingrained in the British constitutional system that it basically has, on its own terms, a justifying capacity. But there is also implicit authorization, and I think in EU law, if anything, we are dealing with merely implicit authorization. So we are interpreting law, and through that, we are making it. We are basically packaging everything as interpretation. I will come back to that point in a moment. We also, the Court of Justice may say, oh, we cannot apply law to facts, and if we cannot apply law to facts, then we have to use general statements, right? Because if we made our statements fact-specific, then it would be like applying law to facts. Whether the court actually stays true to that directive, it's another question. So it's all about not being intentionally regulatory, intentionally political. It's all almost like a byproduct of just deciding the case at hand. And that's the preferred self-portrait. By the way, self-portrait is a standard vocabulary used in political science and legal sociology. So that portrait, I mean, the fact that it's the preferred official portrait, I mean, I give you an example of the Costa judgment, a very old judgment, and you look at the language there, that the court says, we are just deducing the meaning of community law from the wording and, interestingly, the spirit of the treaty. And that's basically all we are doing. There is just the process of deduction, nothing more. So how come that self-portrait has become so prevalent? Because we know it's partly a myth, right? So how come? What are the different strategies that the court has employed in order to feed that interpretation narrative? And I just listed a few of those strategies. I hope, again, they are not too controversial. For example, with effectiveness, principle of effectiveness, or a fait utile, the interesting aspect there is not that the court is using it, but that it is frequently described as an exercise in systemic interpretation. And obviously, we could go one by one and show that, how much interpretation of the textual message is there really. But I'm not criticizing, I'm just stating things as they are. And obviously, we also have references to the system of the treaties and the spirit of the treaties. And we have another very interesting phenomenon that I love tracing when I read judgments of the Court of Justice, where the Court of Justice is sliding between the argument that something is not prohibited, so we can do something, into the argument we have to do it, as if can or may and must were one and the same thing. And obviously, there are also references to general principles, and I'm talking here about judgments where the general principles are not the input, it's not what the court is using to arrive at the outcome, but it's actually that it uses general principle as a packaging in order to state a particular proposition, because then certain consequences may follow from it. For example, the rule in question may be horizontally applicable. So, but the self-portrait is not without cracks, because there are inconsistencies within the self-portrait, which is why, for an academic like myself, it's very interesting to observe it and record it for, other interested parties. And here, I'm not talking about academics saying, you, the court, are giving us a false picture of what you're actually doing. Within the case law and within the procedures of the court, the self-portrait is actually not always accepted and it cannot be consistently supported. And what I mean by that, and again, I like the transparency of the court referring to settled case law. And again, I invite you to consider the vocabulary, settled case law. So that means that there was a moment in time where the case law was not settled. So that means that something happened between the period of time where the case law was being developing and was not presumably binding yet, and the current moment when it is now settled and is binding, and conclusions may be drawn from it. So you see that the court acknowledges through that vocabulary, through that phrase, that a change has been instituted. And there is also there is also the plain recognition of the fact that development of the case law is part of various doctrines. So the doctrines that the court itself developed integrate the fact that law changes through its judgments, because whether the state will be liable in damages may change depending on whether there was already case law on the issue or not. Whether there is an obligation to refer a case to the Court of Justice of the EU by a court from whose judgment there is no further judicial remedy. Again, that obligation will change depending on whether there is case law on the matter or not. So we can see that it's almost like there are glimpses of recognition of the actual state of affairs, but there is also repeated denial that we are making law, we are actually changing law. The law is different now than it was before. So I'm a scholar, I'm a legal scholar, and I have a dilemma, because I would like to account of this. I would like to come up with a framework, with a theory, with a way of thinking about all of this that is true to what's happening, but it's also true to the values that the law subscribes to. I'm not just a scholar, I'm a legal scholar. I am bound by certain values, certain principles. So I cannot quite adopt what I described as the external perspective, the perspective of a political scientist or a sociologist. Because if I adopt that perspective, I would have to say it's all just power, political preferences. It is all just exploitation of the position, of the fact that once the reference is returned, lower courts, we have all this analysis why lower courts have a self-interest in complying with EU judgments rather than with judgments of the higher and constitutional courts of its own state. We know that analysis, but it uses concepts as ideas, concepts like power, which is why the title of my presentation doesn't contain the word power. It contains the word authority, yeah? And we know the difference between these two. So I accept. I cannot use political science, I cannot use sociology, because it's not allowing me to engage with the values of legality. So can I be formalistic, like so many scholars are? So many scholars. Basically adopting the self-portrait as their own scholarly framework. Well, I can't do that either, because I don't think it's honest, and I want to be honest. So let me look for a different theory. But the different theory, it's not easy just to come up with a theory that does so many things at the same time. It accounts for the justificatory gap, the fact that the text doesn't quite support the conclusion, yet that there are steps in between. It accounts for the fact that judges make law, and I don't want to banish that, I want to embrace it, but in the same time, I don't want to empower judges just to do whatever they want, because that's another danger, right? When you come up with a theory that recognizes judicial lawmaking, certain actors may read it as a theory of empowerment, where it's completely unrestricted what is that they are entitled to do. So what can we do? Well, I went through the usual suspects, legal positivism, legal realism. And, on the slide, I briefly explain why neither legal positivism nor legal realism give us the answer, especially legal positivism. Again, I'm so surprised that so many legal scholars are positivists. I simply cannot comprehend, why positivism is so strong. Not when they talk about law, during lunch break, but, when they account for it, when they write about it. That the problem with a positivistic perspective is obviously it relies on the idea that there is a valid, legitimate enactment to start with. So with respect to judicial law, we would have to use a circular argument. There is no empowerment in the treaty. So the judgment itself would have to empower its own, is the institution that made it. So cannot be accepted. But the main weakness of the positivistic perspective is that it does not comprehend that the authority of the judgment may come from the content of the judgment, right? Because it's a procedural legitimacy framework. The content of the judgment is what empowers the institution to give that judgment. Unthinkable, right? So what I propose is that we may start returning to this bunch of theories. There is no good name for it. There are many scholars that are working within that school of thought, which is law as reason. And law is the reason for action. The way I translate it for the purpose of judicial institutions is as reasoning with law, not with text, reasoning with law. Yeah? It's a difficult concept to grasp, and I'm not saying it's perfect. It's difficult. But it is, I think, an improvement on the theories that we have been relying on. So, obviously, I could refer you to many scholars that are working within that tradition, but I cannot omit Jerzy Wróblewski, who wrote a beautiful book called Judicial Application of Law, obviously Neil McCormick, Legal Reasoning and Legal Theory. The essence of that argument is that we have to see judicial decision-making as the process of justification. And that, as I said before, the validity of the judicial decision is assessed by reference to the reasons that support it. Yeah? And what I mean by that, and I will emphasize that point yet again, is that those reasons don't need to be textual. They don't need to just be residing within the text of a treaty or a piece of legislation. So we accept that justification must be rational, but it also must be legal. And I've just told you that it may go beyond the text. So what else legal input is there beyond the text? And that raises a really big question, the biggest question there is for a legal scholar. What is law? I'm not going to try to answer that question here. What I would put to you is that there are legal principles that one can draw on as a judge. The important thing is to accept that there are certain arguments that are not available because they are political or too consequentialist, and there are certain arguments that have to be engaged with. So we are talking about judicial discretion. Let's be happy with judicial discretion. Let's recognize judicial discretion. But as Hart would say, Dworkin as well, discretion is constrained. So let's focus on the constraints, and then the constraints need to be properly spelled out and articulated, even if they are inconvenient for the court that is making a decision. And I think this is where the big shift really is. By accepting that there will be certain legal arguments of principle that are inconvenient, so they are not supportive of the conclusion that perhaps the institution wants to reach. I could speak a lot about incrementalism and the negative dimension of legal reasoning by analogy, but I don't have the time, so I will skip that. But what I'm saying is that there are a lot of mechanisms that can be built into a theory that explains how come the judges, on the one hand, are making law, and in the same time are constrained by law, because that's the big conundrum. So let me give you two examples. I have one example from the EU court and one example from the EFTA court. I'm not going to discuss these cases very extensively. I picked two cases that are fairly similar because they can be portrayed are concerning an employment relationship, so a relationship between arguably two private parties. And we are looking at what's proper or acceptable, what's expected under what I discuss in the publication of mine as the interpretation framework. So this is the KL and X is a judgment where the national court, the EU Court of Justice, mandated the national court to impose liability on a private employer who complied with national law. That national law was found to be incorrect, i.e. incompliant with the EU directive or the Charter of Fundamental Rights. Obviously, that's a separate issue whether in that particular case in compliance with the charter could have been invoked. But what we have, unfortunately, and I'm sorry to be critical, in a judgment, we have a manifestation of what I call the interpretation framework, i.e. the court is claiming that all it's doing is just interpreting EU law, and here comes an outcome. The national court is obliged to disapply the national law on which the private employer relied. It seems, I mean, this judgment seems justified, right? I mean, the court is citing the directive. The court is engaging with Article 47 of the Charter. The court is applying even its established case law on when the Charter can be horizontally applicable. There are references to the sufficiency test about, when the provision of the Charter is able to confer rights and all of that. And yet, when we finish reading the judgment, I think we are left unsatisfied, because the big question is not addressed. The big question is being, why someone who relied on the content of national law, and followed that law to the letter, where at that time it was not clear that it's not in compliance with EU law, now, today, has to pay compensation to the employee that the issue was termination without giving reasons for termination. They thought they could. It was a fixed-term contract. Under Polish law, it's a Polish case. Under Polish law, they could actually fire someone without giving reason why when it was a fixed-term contract. Yeah, and the court itself required so many paragraphs to explain why that was actually compliant with the directive and why it was in compliance with Article 47 of the Charter. Well, it had to look at the Charter as well, because if you just look at the directive, then it would be prevented from relying on that principle against the private employer by the Marshall prohibition, by the prohibition on horizontal direct effect of directives. So is actually the outcome explained? And is the outcome explained to the party to whom the outcome should be explained? Not to the national court, but to the private employer that will have to pay the compensation. And my argument is that actually the outcome has not been explained, partly because when you operate within the interpretation framework, you don't feel the need. You are not being pushed to engage with arguments. And one of the fundamental questions of any legal system is when a public law duty can be the basis of a private law duty, a private law obligation. Yeah? Especially since almost all legal systems subscribe to the principle of correlativity of private rights and obligations. That is not even mentioned as an issue, as a consideration. Well, obviously, it's not mentioned in the directive. Why would it be? But it's a principle of a legal system. It's an ingrained principle of any legal system that you cannot just take public law duties that are imposed on public institutions, and somehow, by miracle, generate from them a private law obligation. But I think there are other examples where I think the outlook is a bit more optimistic, and I'm just saying, I'm picking just those cases. Every case has to be interpreted, analyzed on its own terms. But I was really, when I started reading some of the case law of the EFTA Court, I was really struck by this decision. I'm certain it must have been hugely controversial when it was delivered, when Norway was told that it cannot offer preferential treatment to female academics by imposing on universities the requirement to employ a certain number of female academics, where, and I'm not just talking about the situation where there are two equally competent candidates for the job, one female, one male, and the university or other institution is being given permission to employ a female academic, just to rebalance the gender ratio of academic employment. No, we are talking where these particular provisions actually obligated universities to employ female academics, making it impossible for male academics to obtain certain positions. And the decision of the EFTA Court was that this was incompatible with the EEA agreement, And again, I'm not discussing the outcome. What I'm saying is that what I see in the judgment is a slightly different approach. A lot of cases are being a lot of cases of the Court of Justice of the European Union are being relied on, even though they didn't have to, because we know that not all of the case law of the EU court is binding on the EFTA court. But there is, the cases are not just mentioned for the legal proposition from the rule that they instituted, but are actually discussed also for the reasons why to have such a rule is a good idea. Yeah? And I think this is a very important point, because I'm sure that there were many female academics in Norway who were hugely upset by the judgments. And this is to them that the decision needs to be explained, that we are doing what's just, even though you may find it regressive. So the judgment is using substantive reasons to support formal reasons. Yes, on a certain view, one could say, why not just mention the case law of the EU court? You know, we integrated the principle of homogeneity, and we are done. We don't have to go into the substantive arguments, but the EFTA court did. So this would be an example, in my view, of the EFTA court doing what I advise it should do. I did it on purpose. Obviously, I had to pick a positive example, right? So is what I'm saying only theory, or should it also be practice? I understand that both the EU court and the EFTA court are collegial courts that when cases are being decided, we have judges coming from different legal traditions, judges accepting different modes of reasoning as properly judicial, right? So we can even have not only disagreement about the outcome, but we may, among the judges deciding the case, but also what reasons need to be used to support a particular conclusion. But, I would advise courage, I would advise transparency, and I would advise really thinking very hard to whom the decision needs to be explained, to whom the decision needs to be acceptable, who are the actual addressees of those judgments. Not just lawyers, not just practitioners, not just academics, and definitely not just judges in national courts. So what I would suggest that perhaps, now that the legal systems are maturing, that it's a good time to change the self-portrait a little bit, to engage with substantive arguments a little bit more, and to really explain when the judgment is being passed. Okay, this is where the case law has gone so far. These would be the new element that we are adding to existing case law. So, recognition, explicit recognition of a change. And we can make this further step because these are the good formal and substantive reasons that support such a change. And I think, one of the reasons why, this change in the mindset, you can call it, and also in practice should be encouraged, because the big elephant in the room is retroactivity of judicial law, EU law, but any law. Retroactivity of judicial law is really a problem, and I wrote a big case note on the Cassens judgment, tax case, where I think, again, a shocking lack of recognition that what's going on here is that a new rule is being applied retroactively. And we can pretend that the law has always been what we say it is, or we can say, no, we are actually changing it, and we have to show to those whose legal position is going to be affected that what we are doing is actually we are building on existing set of principles. Those principles have been already in operation beforehand. What that means is that, again, sometimes judges will have to say, we would like to do it, but we cannot, because we cannot justify it in a legitimate way, even if we think it's a good idea. Controversial in the context of a supranational court, perhaps, but I will put it out there. And we know that the Court of Justice of the European Union, and I'm sure the EFTA court has many critics, and showing that kind of, that kind of honesty, that kind of transparency, that kind of, subjection to constraints, it might be one of the ways in which the criticism that, Hartley, Dihus, and Somek. Somek is known for saying that the case law of the EU court is groundless. Yeah, I don't know if that's the message that the court wants to propagate. So perhaps a little shift in the narrative and in the practice is advisable. Thank you so much.
Thank you, Dorota, for this very lively presentation with some kind of hard words for us judges. But I think that was intentional after the lunch break.
Yes, I wanted to wake everyone.
Yes, excellent. I think you have been quite successful for that. Before I hand over to the floor, in a way, could one sum up your presentation by claiming, dear judges, you have to change your mindset. Your job is not delivered just by rendering your judgment. Actually, you have to sell your judgment. You have perhaps call in some marketing people, which then explain you how you have to actually word your judgment that it will reach the audience. Let's say the judicial tradition is much more, in a way, if you have take this common communication model, sender, receiver, we are judges, we are sender. We don't care about the receiver. We make a very nice operation part, and that is it. Now you ask us, actually, sorry, you have to draw your attention to the other side, to the receiver. And please be honest.
Yes, that's part. Honesty is definitely important, but as I say, it's very important for me that what I'm trying to argue is not interpreted as a blanket authorization just to use whatever arguments are considered acceptable, because if we go down that path, it's a dangerous approach, because we will be looking for majorities that are going to support, right? So we will be trying to please a certain group in the society in order to gain support from them, in order to ex post facto legitimize a decision. So that's not what I'm advocating. What I'm advocating is a clear expression of legal principle. So, for example, in private law cases, we have the principle of good faith. We have the principle of unjust enrichment. We have the principle of mutual respect towards the parties in a private law relationship. So there are already legal principles which are ingrained, which are recognized as proper legal principles. They are not just, arguments of convenience or arguments of political influence. They are actually proper legal principles that can be drawn on. The difference is that they have to be serving as input. It's not like we are not going to use principles to state the solution, the outcome. We are actually going to rely on a principle, show that it's ingrained, and then the judge is going to explain what kind of work it is doing in the reasoning process, how it is fair between that claimant and that defendant, And I'm sorry that I'm adopting a private law perspective here, but I think a private law perspective is very instructive, because in a private law case, like in a tax law case, for example, you have a private individual who is going to lose, who is going to pay, maybe go to prison, and so on. So that kind of opens your eyes to the real challenge. The judgment has to be explicable to them. They have to understand why what they are facing is fair. And just the fact that the court is a supranational court that is giving preliminary rulings or advisory opinions, yes, we can play that game, but we know very, very well it's a game, right? Because ultimately, the instruction goes to the national court to do or not to do a certain thing. And it's also about taking responsibility. Yeah? You cannot hide behind this interpretation/application divide. So I am definitely advocating proper engagement with legal principles, not going beyond law, but broadening the idea of law and incorporating ideas that are already part of the legal tradition within judges operate.
Thank you. If I'm looking a little bit to the watch and I see, yes, there's one. I take one question, yeah, perhaps two questions, but Hilmar Hocht, President of the Liechtenstein Constitutional Court, please.
Yeah, thank you. You have already introduced me. I think your presentation was very inspiring, and actually there was 2 years ago there was a symposium at the University of Innsbruck on the reasoning of the German-speaking constitutional courts. And so these issues that you have brought up were discussed there too. And we claim, the Liechtenstein Constitutional Court, that we are actually in a dialogue with the other branches of government, but also with society as a whole, and also with foreign courts, because for a tiny country it's important to also look abroad. And in this respect, of course, it's essential to be transparent and to really to be able to have this dialogue, and that also includes that one might change one's opinion. And as you said, of course, it has always to be relied on principles, on legal principles, but the circumstances can change, convictions can change, and it's very important for us to make clear when we change a case law, a practice. That's very important. Too many courts don't do that. They claim there is just continuity when there is none. So I think this is very important, especially for constitutional courts and of course international courts to be transparent. But there are different traditions too, especially in France, for example. It's not the idea that you convince, you state what the law is, and that's it, and the recipient has to accept that. So we have a different approach here, and I think it's in Anglo-American law, it's very common that you try to convince, you use rhetoric instruments also to have an impact on lay people, to not only on lawyers, because especially constitutional courts, they should speak to the big public. Thank you.
Yeah, well, I live in a common law jurisdiction, and obviously some of the statements that I'm making are inspired by common law theory. So, because the issue of judicial lawmaking has been part of the legal landscape for a legal system like English law for centuries, they actually have been trying to conceptualize it and have been trying to explain how come that we can maintain that our judges are constrained even though they can make law. So what is the appropriate way for us to think about it, so we are not just allowing judges to do whatever they want, but we are still respecting their power to make new rules. And part of it is as you say, it's the dialogue with other branches of government. It's the fact that very often an English court would say, yes, we would like to make this rule, but it's actually for Parliament. Yeah. So that's is it possible for the EU court, for EFTA court, to put forward such a claim? That the law runs out. The law that we as judges can rely on is running out. But we think that it would be good to have such a rule in place. Maybe the EU legal system is not yet mature enough to incorporate that kind of cooperation between the judicial branch and the political branch. Maybe because it's so much harder to make political law in the EU. Maybe because the court has got used to the fact of having this very important policy-making role. And it's difficult to go back, right? And say, actually, maybe now it's the time to show some restraint, but not restraint by not making law, but is restraint in the manner in which the law is made. So yes, thank you for your comment. But even Cour de Cassation in France is now thinking of making its judgments more explicit. So definitely, the direction of travel is in direction of transparency.
respect to your reference that we're running out of law at the EFTA court, no, that's not a problem, but we are running out of time. Sorry, we have different, but we have to stick with the time. I have actually 4 different which raise, so, but looking to the time scale, I think we'll have to give also then time for Georges Bauer. So thank you very much for a very inspiring lecture. Thank you. Our second presentation is by Dr. Georges Bauer, someone who is very well known both to myself and to the EA legal community, and who indeed previously addressed this conference some 10 years ago. It must be about around 2015, something like that, I think so. Georges has several roles at present. He is the head of legal research of the Liechtenstein Institute, a research institute to do scientific research in the fields of history, politics, law, and economics relating to Liechtenstein. In this capacity, for example, he also bears kind of a head of as a co-editor together with some other people which are present here, Professor Harald Fredriksson, Gunnar Thor Petersen, as the kind of joint editor of this very famous EFTAstudies.org. So that was my marketing claim. I think it's quite an interesting place to read about what's going on in this EA-EFTA world. Besides that, he also advised the government of Andorra on EU association matters and is Vice President of the Liechtenstein Administrative Appeals Board. In advising the Andorran government, Georges has a unique background, having been not only Assistant Secretary General of EFTA from 2012 to 2018, he also was previously Deputy Head of the Liechtenstein Mission to the EU. Georges is ideally placed to answer his perhaps provocative question: the EU's association agreement with Andorra and San Marino, in what way is it EA plus? Georges, the floor is yours.
Thank you, Bernd. Too much honor. Personally, I would have liked to continue listening to Dorota. So, Mr. President, ladies and gentlemen, many thanks for having me here. It's late in the day, and I therefore serve you with a lighter dish than what we have heard before, less academically rewarding perhaps. I will, however, try to keep slightly above Wikipedia level. I'll follow the following structures and start by saying what the AMS states are, because that was, in fact, how they were dealt with before Monaco dropped out. So it's about Andorra, Monaco, San Marino, microstates, you would say. I will, however, not elaborate on the notion of microstates, because except for their size, they have about as much in common as Norway with Malaysia, Côte d'Ivoire, or Poland in size. Naturally, they are small, and that adds to certain problems they might have with regard to incorporation or to association or even integration. However, the subject is more interesting than might appear from the sheer size of these countries. The AMS states are independent states with small territorial extension, which maintain specific relations of proximity with the European Union, and that is relating to the Declaration number 3 to Article 8 TEU. That was introduced in the context of neighborhood policy, but was prior to, for instance, Liechtenstein, getting into the integration, on the integration path. The current relations with the EU, at present, there are different agreements with the EU, all with a customs union, depending on what kind of relation they have with their neighboring EU member state. This can be something like Turkey, with heavy border controls, or it can be something very light, as for instance San Marino with Italy. They always found some way of making things easier if they wanted to. There's a trade agreement and a monetary agreement. All of them apply the euro. And as you see, Monaco, San Marino, and Andorra have rather similar ways of being engaged with the EU. Despite various agreements, no comprehensive cooperation between the AMS states and the EU has ever been concluded yet. And a further development of relations with the AMS states was first discussed in the EU in 2010. That was in the Italian presidency, and I suspect it had to do with the fact that Italy wanted to bind San Marino into the union legislation process, and also because the EU wanted to integrate the last ones of the non-EU Western European states and thus complete the market. And this is also to be seen in the wider context of the debate on progressive integration of the EFTA states. The Council of the EU indicated that similar steps should be taken with regard to the AMS states, and also the AMS states were interested in developing relations. But it was rather I'd say, a political push than one that was triggered by economic interests or anything of that kind, because honestly, there aren't too many economic exchanges if you compare to other relations. I'd like here to point to a very nice and comprehensive new contribution on Andorra by Graham Butler that is going to come out around this time, I imagine. Who is interested, I can give you the details of the publication. As to the negotiations, so having accepted that both sides had an interest in getting closer, in 2012, the European Commission identified possible options for further integration, namely status quo, sectoral approach, framework association agreement, participation in the European Economic Area, or membership of the EU. The Commission favored options 3 or 4. Norway, then followed by Iceland, objected to option 4 in an EEA Council. I suggest that this has to do with the internal political balancing of Norwegian politics in the first place, but Halvard can maybe put me right if I'm wrong. So the Framework Association Agreement was the remaining option. In 2014, the Council gave the Commission a mandate to negotiate one or more association agreements with the AMS countries on behalf of the EU and its member states. The formula was imposed by France to keep flexibility with regard to Monaco, because Monaco was already part of the customs territory and had a very close link with France, and a lot of the internal market issues were already covered by France. So the French wanted to keep some, let's say, of their mainmise over the Monegasque integration. One agreement, but 3 bilateral relations. So there's a head and then bilateral agreements, as you might know them from the relationship with Switzerland, but not in the same manner. A priori, this should not have been a mixed agreement, contrary to the EA, but there is no final decision yet. Because this is not yet decided, the Andorran government, which said it would hold a referendum, has to postpone the date every time. And that renders the government rather nervous because, of course, the longer you wait, the less certain the outcome might become. And the odd story, which is not really anything legal, but it's rather funny if we talk about today's political situation. The big stumblestone was France. France, the notion of non-mixity, or the argument for non-mixity, for mixity, I'm sorry, was a small contribution to the budget. And in the end, there was an argument to say, okay, this is so minor, maybe with the agreement of all the member states, we could agree that it is politically a non-mixed agreement, and the member states agree. Fine. So that was orally agreed with Monsieur Bayrou, and 5 hours later he was out, but not due to that. So now the Andorran government will have to make its case again with a new prime minister for as long as he's there. Then there were council conclusions on a homogeneous, extended single market and EU relations with non-EU Western European countries, which, as I said, now also relate to the AMS states. The negotiations are about a more far-reaching relationship, of course, than they have today. Path dependence suggests, of course, that you draw on existing models. The content is, in principle, comprehensive association to the EU's internal market. The institutional framework should, in principle, be parallel to the EU system. And the context, of course, much of this happened in parallel with the institutional negotiations with Switzerland and with the UK, so Brexit. Like the EFTA states, negotiations have shifted at some moment on the EU side to the Secretariat General of the Commission and the EFTA Working Group of the Council, which are now in charge to assess step by step whether the results are sufficient and can be then put to member states and for decision and parliament. So this went on, and suddenly on the 15th September of 23, Monaco and the EU suspended negotiations. The official reason was that the EU demanded too much with regard to non-discrimination in Andorra. For instance, social support to Andorran citizens, to the 4,000 they have, that should be opened to all Italians and French, etc., which they then said, sorry, we cannot do that. But I think there was much more opposition by the financial sector, which was much more powerful, and that then killed this negotiation. But they did it somehow more elegantly than the Swiss when they said, no, we stop negotiations, and slammed the door in the face of the EU. On the 12th December 2023, it suddenly went rather quick. The EU, Andorra and San Marino concluded their negotiations. Follow-up was and is legal scrubbing, translation, etc. And that, as I said, Andorra will hold a referendum. And we still don't know when. Now, what is this draft association agreement? The structure looks about like this. You have this framework agreement and framework protocols, for instance, on financial services and on other issues. And underneath you have the Andorra Protocol, San Marino Protocol, which are more or less identical, but respect some specific issues with regard to the prior relations these two countries had with the EU. And then each of these national protocols have their annexes. And these are practically identical with those of the EEA, plus 3 more which are being transposed from the prior relationship they had. The funny thing is, they have no mutual market access, and I think that came from the original solution, and also the idea that Monaco has such a special status that they wanted 3 bilateral agreements. Today, that effectively doesn't make sense anymore, but obviously they didn't want to change the logic of the agreement anymore in the last moments of negotiations. That might come at a later stage. The 3 additional annexes to the 22 we know, and with the name numbers from the EEA agreement, are customs, agriculture, and trade. And then there is, and protocols. For instance, there is also the Protocol 1, we know from the agreement. So standardized adaptations like citizens of Andorra and San Marino instead of union citizens with regard to Directive 2004/38. Now, what's in it? Very simplified. It looks about like that if we go across the Internal Market Association. I'd specifically like to mention that there is also a border control agreement being negotiated in parallel, or not in parallel now, after the association agreement has been drafted. This is triggered by the entry-exit system that is supposed to enter into force end of October. So the EU wanted to avoid having a hole in their territory for third country nationals, because the problem is, of course, if they go to Andorra or San Marino, no control for the EU to see whether they overstay their 3 months, for instance. The EEA EFTA states, the 4 EFTA states, having joined Schengen, will of course have to replicate this agreement too. I asked at the time whether they don't want Andorra and San Marino to become Schengen members, but they said, no, that's not the point. We simply wanted to have something rather quickly, because negotiating Schengen and then having a no in the Andorra referendum would cause major havoc, and so first go step by step. The interesting thing is, during these negotiations, the Malta case, you all know, came up again, because in the context of Andorra and San Marino, Spain and France have a rather big role. So they will assess, with regard to third country nationals, whether they have a problem with Andorra giving out residency. And so the agreement foresees that the residence permits need to have a real link to the country. And that was discussed exactly when the court case came out. So it's not about passports, but mutatis mutandis, the same thing with regard to residency. The negotiations have increasingly evolved to stay as close to the EA as possible, as I mentioned, and the content also reflects certain legislative development in the EEA and otherwise, like on financial services, freedom of establishment, sanctions, restrictive measures. And there is, of course, the unresolved problem of managing to incorporate the EU legal acts, because these 2 countries have no EFTA secretariat to prepare the acquis and so on. So that is something they will still have to deal with the EU and see how they will deal with it. If I quickly enter into the question of financial services, there's this Framework Protocol 3, which is, again, an agreement in the agreement. And that reflects very clearly how little confidence, and here I'm with you, the EU had in simply letting these countries deal in the same manner as, for instance, Liechtenstein. And they have really been tightened very much. And so the regulating access to financial services internal market. This came up very late in the negotiations due to some member states having problems. There was a concern about the capability and capacity to implement huge and critical financial services acquis within transposition delays. And they invented something like a staggered approach, which means there's a gradual access to parts of financial services internal markets, banks, insurance companies, etc., step by step. And over 15 years, these countries can say, okay, we now want to start with the banks. We set up the system. You tell us you're satisfied with it, and then we go over to the next one. And they have the liberty to say, this is a sector we are not particularly in, so we are not interested for the moment. So it has become rather flexible. And there's a very strong monitoring from the EU side. State of play, while a very long problem existed mainly between Italy and San Marino on whether the supervisory system was sufficient, this has now been solved, and it will be solved by including into that protocol a mention of a separate agreement between San Marino and Italy on that issue. Not quite elegant, but obviously it serves the purpose. Easier task is freedom of establishment. Annex 8, joint declaration by the EU and Andorra on freedom of movement of persons. San Marino didn't obviously have any kind of problems there. And a declaration of Andorra on the specific situation of the country and on safeguarding security and public policy. Same for San Marino. And similar as for Liechtenstein. They have followed the system of Liechtenstein, having certain quota and having to increase the influx in a certain way. And the interesting thing is, if you make the count, Andorra, for instance, would be obliged to allow at least 700 or hand out 700 permits per year. Currently, they do, without all that system and without the integration, 2,000. So in fact, they could restrict it to a level lower than what they have without association. And then the issue of sanctions, restrictive measures. You know that in the EEA, this is rather soft law, but it is, I at least contend, an obligation based on the political dialogue and stemming from Article 29 of the TEU. And usually these restrictive measures will then, in the EU, be transferred through Article 215 TFEU into concrete measures for the member states, which is not available for the 3 EEA-EFTA states, so they have their national basis in order to then subscribe to the EU's restrictive measures. With regard to Switzerland, there was an irritation between the EU on this sanctions mechanism because there was nothing. But the EU demanded, at least on a political level, that Switzerland would not circumvent at least these, or allow to circumvent these restrictive measures. That has now been written into the Andorra-San Marino agreement as a legal obligation. So there is a soft law obligation to follow, or invitation, but there is a legal obligation to at least see that EU restrictive measures are not circumvented. Now back to a bit more theoretical approaches. We have the conditions, the criteria for participation in the internal market. So you all know the Interlaken criteria with the community, or today union integration, taking precedence, the autonomy of community or union decision-making being protected, and the balance between rights and obligation. And that translates into the so-called institutional criteria, which the Commission spelled out usually in their letters to the Swiss government when over 15 years negotiating with them. So you have the institutional criteria, firstly, on a systemic level, which are homogeneity, which are dynamic incorporation, and then those rather functional with the independent international surveillance, the judicial review, and dispute resolution. I'm not going to bore you now with the structural principles discussion of Marisa Cremona, but it's a bit in that framework. Now, how does this translate into the Andorra and San Marino agreement? You have the leading principle, homogeneity. You have the incorporation, which is also dynamic. You have the joint committee of the two countries. I'm curious to see how they will do it in practice, whether they will have it jointly or not. You have the surveillance directly by the EU Commission and with no one of the two countries sitting there. And second, and maybe competition bodies of the neighboring states. That's not yet decided. Could be Spain, could be France, or even Portugal. Judicial review, the Court of Justice, and Andorran and San Marino's courts may submit requests for preliminary reference, which are binding then in the result. And dispute resolution, again, to the CJEU, and upon request of either party, to the contrary of what we have in the EA agreement. So, comparison and evaluation. What is it with this EA plus? As has been said, Maroš Šefčovič said in his press conference that this association agreement was going further than the EA agreement and therefore was EA plus. I'm saying that in Liechtenstein, EA's EA plus sounds quite different because in the second referendum Liechtenstein had to have with regard to its integration into the EA, there was the problem that Switzerland had said no in the first place. And so one had to find something that would harmonize the EA agreement on the one hand and the customs union with Switzerland on the other. So the government's PR action was to say, we are even going to have EEA plus, the Swiss customs union. So just for your benefit. And clearly, that might change the structure. You know this picture from the Brexit. And there you had the EEA as the closest to the EU system. And if Mr. Šefčovič is right, this will then happen and look like that. Now, is it really EEA plus? The EEA is an inter-organizational agreement, I would suggest, because you have EFTA minus Switzerland and the EU, but it's EFTA. And secondly, you have the EU with Andorra and with San Marino, and again, they have no link between each other. With regard to the substance, Šefčovič's statement is not wrong, as the association agreement incorporates developments from the last 30 years and also things the EU might have found bothering with regard to discussions in the EA context. Andorra and San Marino, in addition, as I said, to the 22 EA annexes, have their 3 more. And the rules on incorporation are stricter. For instance, there are implementing measures to be enacted within the EU time frame unless there is a constitutional requirement. And the delay on constitutional requirements is clearly set. So after 6 months, there is an automatic, we'll see how this is going to play practically, but there is an automatic suspension that might come in. And certain rules that we have in even in our EFTA context, have been elevated at level of the association agreement, like the automatic or simplified procedures. And then, of course, there is anti-fraud cooperation, which has also been integrated into the agreement as such. As I said, I regard the EEA agreement as an inter-organizational agreement with a two-pillar institutional structure. Of course, that bases on a legal fiction. Article 96 and 128 suggest that you operate, at least these three countries, operate together. Not in all respect and not for all the agreement, but to a certain extent. Therefore, I'm not entirely sure whether the idea of certain of our representatives in Brussels will fly when they say, well, we should do away with the one voice principle, because this fiction has been created to mirror the EU side. And therefore, I think you couldn't deviate from that one. This ultimately also leads to a multilateral mutual system of recognition and access. As I said, the association agreement associates two states with the EU. It's essentially bilateral, and the EU's institutions are in charge for the associated states as well, and without their participation. From an EU point of view, there is institutionally more integration and less encroachment on its autonomy than in the EEA agreement. And while we have started to differentiate the character of homogeneity, judicial, etc., the judicial doesn't apply here, because it's the Court of Justice, which decides and will maybe reflect certain specific issues of the agreement, but not with regard to how they are going to interpret it. And institutionally, however, and from an EFTA point of view, the EEA agreement is probably more sovereignty-friendly. With that, we are back to a certain wording of the Norwegian Supreme Court. And the association agreement contains move from an international to a fully supranational nature. And in the association agreement, the Court of Justice judgments are binding. And there we are. Thank you very much.
Thank you very much. Georges, thank you very much. I think the devil lays a little bit in the detail, actually, of this different agreement. For example, I got the feeling that the Commission learned their lesson, you see, after having lived now with the EEA agreement 30 years. So, in a way, homogeneity, that problem we solve with just one court. And perhaps this problem that EFTA states take over, for example, they get the right by taking over a certain thing, but if they're actually going to implement it, time will tell us when. So now I got the feeling, okay, they make it the other way around. You get the right, but suspend it. Prove us that you have implemented all rules, then you get the access. So do you share my view that the Commission, in a way, learned their lesson with these EFTA states, because Switzerland?
Yes, indeed. I think a lot of what the Commission has sometimes been complaining about is reflected in this association agreement. And to be honest, there is also another aspect. I myself learned, again, a lot about the EEA, things I simply took for granted, when reading the association agreement and saying, wait, but we have a different approach here, and we're being treated differently, partly more favorably. And yes, so this helps to look a bit closer at what we have, if you look what they have gotten.
just to, in a way, clarify, one important term is this homogeneity principle. It's clear that it was already mentioned, referred to Article 6 this morning, EA agreement, but that is only binding the EFTA Court with respect to case law rendered until signature of the EA agreement, so 2nd of May 92, long time back. So we have our own obligation on the EFTA Court agreement, Article 3.2, that we are obliged to pay due account. So if you like, it's fine. So, and now if you look to the Swiss negotiated agreement, I don't know how to label that, because if you indicate it's the framework agreement, then it's already say something, and bilateral agreement or package, and yeah, so, okay. I don't know how to really name that. But there, if I understand correctly, there, the homogeneity obligation is very strict. So this, for the Swiss judges, courts, they have to accept the ruling by the ECJ in a way. So nothing in relation to pay due account. And with back now in the next one, there's actually really not a problem. You have just to accept our judgment. How could you explain this kind of involvement of this kind of, in a way, interaction between, at the end, sovereign states?
Well, I think the discussion, I don't think that was really a problem prior, because the EFTA Court already in its first decision, or one of its first decisions, already said we're going to treat even decisions rendered before by the ECJ, we are going to to observe them as if they were rendered after. So essentially there is no distinction between the two phases. And however, I think with the two states, there it is clearly an encroachment on their sovereignty, I would say. But I was astonished to see how little they opposed this. I couldn't imagine this would have gone down easily in Liechtenstein, for instance. It wasn't really a big discussion. Some, prior to the referendum, now say, well, we should have gotten a place at the table, but it's not a major issue. And I'm quite astonished about that. With the rest, I think it is some kind of a development which more and more says, well, the Court of Justice sets the rules, and we don't care anymore about prior being more liberal on prior decisions. That's the one thing. And the other is, of course, I think they have a certain fear that the Swiss might then disturb the picture. Although, if you look at the practice of the Federal Court, they are following ECJ jurisprudence quite to the letter. And the third thing is maybe, never forget, there is, of course, also the national level of decision-making, where national courts will then be European courts, and therefore it's easier for them not having to make some kind of a decision depending on when the court decision was rendered on the EU side.
Thank you. I have already here in the front one question, and then in the back I see someone. Please.
Yes, voila. Thank you very much. My name is Hildur Hjörvar. I'm here from the EFTA Surveillance Authority. Thank you, Judge Hammerman, and thank you for a fascinating lecture. I was hoping to tie this back to the very interesting talk we heard this morning on mutual trust. And I wanted to ask you to speculate as to the type of mutual trust which this special arrangement is likely to inspire, especially given the use of the avenue of preliminary rulings and the surveillance role given to the European Commission, and consequently whether this might endanger or undermine the special relationship mutual trust, dare I call it the BFF status of the EEA-EFTA states by comparison? Thank you.
Thank you for this question. I quickly alluded to exactly that problem in my presentation. And you're absolutely right. it's interesting what they at least said privately on the EU side, because I asked them straight ahead, listen, why don't you have equal confidence in Andorra, San Marino, as you have in Liechtenstein, for instance? And the blunt answer was, well, you've done your job during 30 years. We know how you work. And they will first have to gain the trust. So it's not necessarily that they won't ever trust them, but they first want to see, does it work? Because the relations were, of course, on a very low level. And then there were specific issues like financial services, for instance. Free movement is not really a problem. That's a question of capacity, size of the country. But mainly financial services, there was a lot of hesitance with regard to whether they would be not only capable but also willing to play the game as member states wanted them to. And this may be, and it came not, quite interestingly, it came not from from states that were outside and so we don't know them. It came from those who are the closest. So in Andorra, it came clearly from the French, less from the Spaniards. And in Italy, it came very forcefully, with regard to San Marino, came forcefully from Italy. So it was rather the Friends, the so-called, that imposed these rather difficult, and I don't tell you how this Protocol 3 looked like when we first had it on the table. It was, well, colonial would be a nice, title for how this looked. I do not think, and because what I said in the beginning, because they do trust us and they say openly, we know how you work and that this functions well. I don't think this is to the detriment of the relationship with the EA-EFTA states. So I think unless anything happens in between, or there's a major scandal, or I don't know what, I think this is not going to have a bigger impact on us. Would that answer your question?
Thank you. Then in the very back on the right, there's someone. Thank you.
Thank you very much. Jarne de Geter, doctoral researcher at Ghent University. I think it's very fascinating in this association agreement that there is also this big role for the Court of Justice with the preliminary reference procedure. And that made me think of Opinion 191 with the EEA Court, where the Court of Justice found that this EEA Court, which existed of EFTA judges and judges of the Court of Justice, that the judges of the Court of Justice would then have to, like, two hats. They're sitting on the EEA court and they have to interpret the EEA agreement within its specific EEA context. And they go back to the Court of Justice where they interpret the same identical rules of EU law within the EU context. And in Opinion 191, the court said, well, that might be very hard, if not impossible, for those judges to distinguish between these different contexts with the exact same rules. But now with the preliminary references by San Marinese and Andorran national courts to the Court of Justice, there in the Court of Justice there will be judges with two hats as well, where they answer these questions of these national courts on the interpretation of the association agreement within the specific context of that association agreement, and then they go back and rule on purely internal EU law cases with exactly the same substantive rules, but again within a different context. So I was just wondering, what is your view on this new institutional or judicial framework in light of these observations of the Court of Justice in Opinion 191?
Thank you very much. I think you have a very valid point. And my impression from the negotiations was that this issue that they would have two hats was not at all on their mind, but it was very much about autonomy. So they were really adamant, and I had the impression the Commission tried to prove that they are really protecting the court's autonomy, even beyond what the court asks himself, as expressed in several later opinions, and where they sometimes had some compromises or were a bit more lenient with regard to the bigger free trade agreements or so. But yes, I think it was really a hardcore protection of autonomy, and if possible, not even discuss any way of interference with that.
Okay, I will take just now, I think is there a last question then, please?
I haven't followed in detail, but is it still possible for there to be an opinion on the draft association agreement with Andorra and San Marino?
You mean that the court will issue one?
Yes.
Theoretically, yes. However, it would be probably needed that someone asks for it. And there doesn't seem to be any reason, mainly because exactly the autonomy problem has been dealt with. So there is, in fact, no reason for having an opinion, and I haven't seen anything that would otherwise cause problems from an EU point of view. Therefore, I don't expect anything to come up there.
Okay, thank you very much, George. And again, thank you in a way for laying out this kind of very interesting association agreement, which brings many new food for thought for lawyers. Looking forward to that. Thank you. We will come now to the last point, last presentation of this afternoon. So we will hear the concluding address from our former ad hoc colleague, Professor Ole Mestad. Ole was an ad hoc EFTA court judge from 2006, so really very long, until earlier this year. This was in addition to his existing commitment as professor of law at the University of Oslo, being an arbiter, member and later even chair of the Council on Ethics for the Norwegian Oil Fund, among other things. Dear Ole, allow me to share only one anecdote with the audience here. In my experience, one of the requirements of an ad hoc judge is a necessary degree of flexibility. I was first in contact with Ole back in 2019 when I needed to call him for duty to sit as an ad hoc judge here in Luxembourg. It was a Saturday evening, and after a few moments on the phone with Ole, I understood that he was not exactly in the vicinity. He was, in fact, attending a conference in northern Norway. In spite of the distance, we met in person on the Monday morning for the hearing in Abbé Neumünster. I think Ole must have caught at least 3 flights in order to have been there on time. Without further ado, please, Ole, the floor is yours.
Thank you very much. Good afternoon, everyone, ladies and gentlemen. I think this conference has been an excellent conference with a very good program, so with a progression in the program as well. Now it's a bit falling down, of course, but what I will comment upon also relates to several of the topics that have been covered. So what I want to do is first to say something about what is it really to be an ad hoc judge at the EFTA court. Being a judge at the EFTA court is being a defender of homogeneity and the guardian of the EU-EFTA specific considerations. I think that's sort of trying to sum it up. But being an ad hoc judge is then being on call to fulfill the same tasks, and what Bernd just mentioned was sort of really being on call. But that's not so important. What I want to do is to start with, if I manage to push it correctly. Yes. What I want to do is to say something about some of my cases, 4 of my cases actually, and then based on those reflections, I'll reflect a little bit more on the development of the EA and on the court, and also look forward at the end. But saying what is my cases, I've been sitting in 13 cases and some cost cases as well. So I've been sitting with the presidents Karl Badenbacher and in most of them Paul Reinsson. And the first case decided in June 2008, last one in June of this year. So I followed the development of the court over these years, but much more heavily 2022, 2023, when I was sitting on several cases in a row. But the selection of the cases that I want to comment on, the first one is the Icesave case from 28 January 2013 with Badenbacher, Reinsson, and Mestad. The next one is Fosenlinjen 2, which was in August 2019. And then the joint cases on variable interest rates, the 2 Icelandic cases on interest rates. And then finally, the last case that I took part in, Dart Ride on state liability, which was decided in June this year. So I just have one slide for each of them. The Icesave case. Many of you are so young you don't even remember the Icesave case. But for some of us, that was really something. I remember, at least I think I remember, that the Frankfurter Allgemeine Zeitung wrote before the hearing that if Iceland loses, then Germany have to pay all bank debts in Southern Europe. Okay, we sort of thought about it, but it didn't have anything to do with the decision, of course. But anyway, there was a lot of interest in this case. And what it was about was interpreting the directive on deposit guarantee schemes. You know, all countries have to put up deposit guarantee schemes so that people could sort of get a guarantee that they would get back from the bankrupt bank at least some of their savings. That's basically the idea of the deposit guarantee schemes. Then, as you recall, there was a financial crisis, and that hit Iceland strongly. And really heavily. Nearly all banks in Iceland went bankrupt. And then, of course, the depositors didn't get their money. The question then was if the state of Iceland was in breach of the EEA agreement by not ensuring payment to Icesave depositors in the UK and the Netherlands. So this was raised by ESA. My successor as an ad hoc judge, he was actually arguing the case on the ESA side, so we'll see how the development of the court will be after this. But anyway, that was the issue. And there was this directive on the deposit guarantee schemes, which had not been decided upon. So this was a situation where the EFTA court was sort of the first mover. And there was no relevant Court of Justice cases. And there was lots of arguments, and Netherlands and the UK came up with their arguments. There were several barristers, actually. One, I remember clearly, only talking about smoke and mirrors. That was actually the arguments of Iceland that he commented upon. So, but anyway, it was quite fun. That's not so often in the hearings. So, but this was much fun, but what the court did, and I read again the decision last week just to see how it looks now. It's very good. But what it is basically, is that it's really a thorough interpretation of the directive and based on preparatory works and even reasoning, theoretical reasoning about moral hazard, or even references to literature. So it's, but I think it's a very well reasoned. And the whole point is that it would be impossible to have a deposit guarantee scheme that could cover any crisis, because that would just bankrupt the whole system of deposit guarantees. So it was sort of, this was a guarantee scheme made up for sort of smaller crises, not a crisis that like the one you had in Iceland. It was a moderate crisis, typically one bank or two banks bankrupting, not the whole system. So and here we found that it was a systemic crisis, and that could not be covered. So Iceland won actually, and then there was also a question on discrimination, which I beforehand thought would be the most difficult one, but it was not argued by the depositors' home countries. It was not argued that they wanted to be in the same position as the Icelandic depositors, because then they wouldn't get their money out of Iceland. So the discrimination issue was really strange. But anyway, Iceland thought they would lose, because I remember the press conference when the conclusion was given, and then the Icelandic ambassador, he was sitting up in front in the court, and it was read out by Badenbacher, and the ambassador didn't understand that they had won until he heard the decision on costs. Because then, okay, he looked up, this must be positive in one way or another. Because, you know, often our conclusions are so difficult to understand. They are for lawyers. But the interesting thing here is that this was really the EFTA court going first on a case, sort of having the opportunity really to develop its own thinking about it. Then the next one is the Fosen Line 2, Fosen Linjen 2 from 2019. This was a request for advisory opinion from Norwegian Supreme Court. Already the Court of Appeal had asked the court, so that would be Fosen Linjen 1. But then the Norwegian Supreme Court said they sought, I quote, clarification and amplification or possibly a reconsideration of the Fosen Linjen 1 judgment. Possibly, or maybe even hopefully, you never know what they asked for, but this is what they said. And this was not directly about state liability, but it was about public procurement, so it was local government liability. And what were the conditions for liability for the positive contract interest, the lucrum cessans, the profit, for breach of public procurement rules? And as I see it now anyway, could even a minor breach of the rules lead to having covered the loss of profit? Or should it cover only costs, or should that be up to the national courts? So that was the issue, and this was about interpretation of the directive. And there was an extensive reading of the Court of Justice case law, really trying to understand what has the Court of Justice said. So we ended up with the conclusion that any breach of the rules is not sufficient to award damages for loss of profit. The breach must be sufficiently serious. That was what came out of the Fosen Linjen 2. This was an argument on homogeneity. This was really trying hard to come up with an advisory opinion on what is really the status of EU law as such, and then also EA law. This was not something to drive sort of a special EA agenda or whatever. It was just trying to stick to what has the European Court said. And then the two last cases that I want to say something about. That's the variable interest rates cases, 2 cases actually, joint cases from last year. And this was about consumer protection. Because there were, in the Icelandic banks' loan agreements, there were provisions on the bank's right to unilaterally change the payable rate. And there were references to all sorts of elements that could be taken into account. And the main problem was really how vague can these elements be, because that leaves the discretion, a large discretion to the bank if it's sort of unpredictable. That's the problem, really. So there were 3 directives involved: Unfair Contract Terms Directive, Consumer Credit Directive, and Mortgage Credit Directive. And what we learned, if we already hadn't understood it, is that the consumer legislation within the EU is extremely complex and driven by different schools. Some put the pressure on sort of information given to the consumers before the contract is entered into, while others, especially the old Unfair Contract Terms Directive, really revises or can revise the contract terms as such. So, and these 3 directives, they are of different schools. So in the Consumer Credit Directive and the Mortgage Credit Directive, you can't find the effect of a breach of the directive. So you have to find the effect in the Unfair Contract Terms Directive instead, but not in that directive as such, but in the court practice based on that directive. This was really fascinating because, I mean, taking over EU law, it's impossible to take this over in the sense that it was impossible to comprehend what it was about. So we, at least we felt that we had to set it up. What is the system? How should the system be understood currently? Because this has directives and court cases have developed over time, of course. So the basic task was to make a workable system out of this. But that was also based on homogeneity. The idea was really to establish a loyal interpretation of what's going on the EU side. But as a side remark, I had the legal secretaries to give me all cases on the Unfair Contract Terms Directive of the European Court. There are 3 large binders. And it's really different strands of development within it. The directive is so short, so you can put nearly everything into it. And you see from the court cases, this is really consumer politics. But I think that, again, the homogeneity was what sort of drove us here, and also trying to explain it with not only mutual trust, but just have someone to read it afterwards and understand what they should do. And if you have tried to read it yourselves, you can just imagine how it is for the other judges. Okay, and then the 4th case I wanted to comment on is the Dartride case from June. It's about state liability for judicial decisions. That's very different, I think, on the type of law, because this is really, as you know, was commented upon earlier today, the principle of state liability is a general principle of EA law, stated in the Sveinbjørnsdottir judgment in 98, and very openly said, as we heard, in the Sveinbjørnsdottir judgment. And it's also, the court says that it's an integral part of the EA agreement as such, which I agree on, but that's not important here. But you'll see how the reasoning in that case is based on an EEA principle. It's not based on a EU principle as such, but when because the idea is whatever the organ of the state whose act or omission was responsible for the breach, there would still be liability. In my opinion, it's really sort of a natural development of, or interpretation application of the general principle as it has been stated several times over, but now it was with respect to court decisions. But then with respect to the conditions when you apply it, the court then uses what's set out in the Köbler case, the European Court of Justice. But so in that sense it's homogeneity, but it's homogeneity with a EEA law principle which gives you rules that are similar to the EU rule, but it's not sort of the EU rule as such. But here all the governments attending argued that this was a wrong extension of that principle or interpretation of that principle. So, and reading through it again now after the summer, I think it's a fair discussion of all the arguments that the governments came up with, basically on the structure of the EEA agreement compared to the EU itself. So these are the cases, and what are then the basic outcome here? I think that homogeneity is really, it's at the core of the EEA agreement, of course, as we heard, and in what the court does, and I give some references. Article 1.1 EEA with the homogeneous European Economic Area. I think that's in one sense the most important homogeneity provision. It's very vague. Of course, it's like someone argued earlier today, why don't you start with a principle and argue from that instead of putting things into a directive where it doesn't necessarily belong? But anyway, that's really my impression of what the court has been doing, basically really loyally trying to develop homogeneity. Sometimes it's tried to be a bit more advanced, should we say, but or going a bit further, but not for the last years, at least in my opinion. So homogeneity, and then I wanted to say something about the widening gap. Very often you say, or people say, there's a widening gap between the EEA and the EU. But does that apply with respect to the internal market, which is the core of the EEA actually? I think that there's not a widening gap with respect to the internal market. There's a deeper integration through, it's like we heard earlier today, we're still in the development phase of the internal market, and that applies to the EU as well as to the EFTA court, of course, the EEA side. But the way I understand what the EFTA court is trying to do is really to not accept the widening gap at all, but really using also it's sort of more creative interpretations from time to time, really to not make this a widening gap with respect to the core of the agreement. Because what we see is that the EU is dynamic on all levels, as we know, on the political level, and it's a different world as well. On the treaties, they changed, the charter came in, secondary legislation changes all the time, court cases develop. On the EEA side, it's static and dynamic at the same time. No revision of the main part of the treaty, as we know. That's partly why the application of the sources of EEA law has to change, but then implementation of new regulations and directives is being done, sometimes a bit slow, but at least it's being done, and court cases develop. So I think that when you talk about the widening gap, that is partly because the sources develop somewhat differently. But the rules that the EFTA court tries to apply or to state in its advisory opinions does not deviate very much, or not, hopefully not at all, from the relevant EU rules. But then politically, of course, there is differences. And just looked at the closeness between Norway and EU accidentally. There are currently, as you know, nearly 100 other agreements between EU and Norway. So the EEA agreement is the most important one, but there are lots of other agreements. And this could have been organized in a completely different way. For example, we could become a member, or anyway, you could reorganize it. But I mean, but anyway, but what we have is, among other things, the new EU-Norway Security and Defense Partnership, which was agreed last year, and where it says Norway is the EU's most closely associated partner, including in the area of security and defense. And I wondered if it was only about security and defense, but the reasoning is actually with the EEA agreement at the core, and then all these other agreements building upon it. So even Iceland isn't mentioned here. But anyway, and Liechtenstein, no. But anyway, then that's what I wanted to say about sort of the ideology of the court, and then just a few things about how are things being done or run. The preparation of the cases and the hearing. In reality, of course, it's a mainly written procedure, but the hearing is still sometimes important. In the variable interest rates case, the Commission, there were 2 hearings since there were 2 joint cases. Commission changed its position from the first to the second hearing, for example. So it gives you, maybe you should always have 2 hearings. So, but that's just a piece of advice for those working further. But the lawyers for the parties are very variable. It's really surprising that some of the lawyers are so badly prepared for the way they should discuss or present their arguments. But since it's very much a written procedure, you should just pick up on things and not trying to say very fast all the things you put into writing. Lawyers for the states and ESA and the Commission are normally good. Observations from ESA and the Commission are often really good, although the latest Norwegian Commission report on the relationship between EU and Norway says that the observations from the Commission are now more variable than they used to. I'm not sure if that's correct, but anyway, they are sometimes variable, but normally very good and of assistance to the court. And then how are the judgments written? I remember when I started this, or when I started reading judgments, I thought this is impossible to understand, basically. But now I've become one of them. So, but it is hard to read. For example, the structure, should a legal background be moved to the end so that you could see that it starts with something which has substance? And then the text, I think there is too much paraphrasing of decisions of the Court of Justice of the European Union. But I think the reason is that you want to follow the homogeneity thing, of course. So that's why, I think you use too much of the text from those decisions. And sometimes it doesn't even fit perfectly in. So I think you could do that more freely. I remember I also tried to convince Karl Badenbacher earlier, many years ago, that we should sort of could we just make it shorter and more intelligible, but not. But I'm trying again. And then we also use too many abbreviations and number references to legal acts. That's really it makes it so internal. And then future developments. What will happen if Iceland becomes an EU member state? Then, of course, Norway will be a really great EEA power. But the system could be difficult. But if it does not, should the court have more judges? That's been proposed from several sides, also from the court itself. That may be so. That may be sensible. Depends on the workload, but also intellectually, it may be more fun. That was no offense, but I mean, because you would have a larger intellectual environment. But that would be the end of the ad hoc judges, which is a terrible development, of course. So I'm not quite sure what I would recommend. But then my last words is just a thank you to all the good legal secretaries, extremely important in this system. To the good colleagues of the ordinary judges and presidents, and the other ad hoc judges, of course, and the registrars. And then the last thank you to the service-minded and efficient staff of the court and of my cabinet. Thank you very much.
Thank you very much, Ola. Also from my side, again, thank you very much. We worked on many cases together, and I appreciate very much, in a way, your kind of thinking, bringing issues, ideas from outside. So it was really inspiring. Thank you very much for this collegial work together. Looking to the watch, I think if there would be a pressing one question, I would, if there's no questions, excellent, because then I would just do my last duty on this afternoon and hand over the floor to the President and ask him to conclude this conference, please.
Ladies and gentlemen, distinguished guests, we have now come to the end of today's conference. I hope that you have enjoyed it as much as I have. The excellent contributions of our speakers and the interesting topics they have covered. I would like to take the opportunity to extend my personal thanks to the last speaker, Ola Mestad, for our occupation during this long period as an ad hoc judge at the EFTA Court. As I mentioned in my introductory remarks, we have now been holding an annual conference since 2011. It's a tradition that we intend to continue. Next year, our plan is to hold the conference again at this time of the year, and I hope, of course, to see you all. Now I would like you all to join me for a reception, during which we can continue a discussion over a glass of champagne. Thank you.